Yesterday and the tsunami that resulted overnight, which continues even now. My prayers are with the people of Hawaii and the continental West Coast, as well as other countries, as I encourage the American people to keep those affected in their prayers. Last night, I was surprised to see President Trump on Truth Social go after me and Senate Republicans over what we call the blue slip. Now, to people in the real America, not here in this Washington, D.C. and island surrounded by reality, the people in real America don't care about what the blue slip is, but in fact, it impacts in their states the district judges who serve their communities and the U.S. attorneys who ensure the law and order is enforced. I was offended by what the president said, and I'm disappointed that it would result in personal insults. Now, we're here to do business. That's a very important part of this committee's work, to do our constitutional duties of reviewing people that require Senate confirmation. Good morning. I'd like to welcome everyone to today's hearing. Our first panel features Eric Tong, nominated to the U.S. Court of Appeals for the Ninth Circuit, and Joshua Dunlap, nominated to the U.S. Court of Appeals for the First Circuit. Then on panel two, we'll hear from District Court nominees Stephen Chad Meredith, Eastern District, Kentucky, and William Mercer, District of Montana. Each of the nominees that we'll be hearing from today is immensely qualified. To begin with, I have the privilege of introducing Mr. Tong. Mr. Tong completed his college degree at Yale University, Law School, University of Chicago, graduating with high honors and the Order of the Coif. After law school, Mr. Tong clerked for then Judge Gorsuch, U.S. Court of Appeals, 10th Circuit. He served in a very distinguished role as a Bristol Fellow in the U.S. Solicitor General's office. Upon completion of that program, he clerked at the U.S. Supreme Court for legendary Justice Scalia. After his first Supreme Court clerkship, Mr. Tong went into private practice with the law firm Munger, Toles and Olson. He was there for a couple of years before joining the Department of Justice, first as Assistant U.S. Attorney, Central District, California, and then as counsel for the Office of Legal Policy. At the Office of Legal Policy, Mr. Tong was awarded the Attorney General's Distinguished Service Award. Because a single Supreme Court clerkship was not enough, Mr. Tong went back to the highest court for the law clerk for Justice Gorsuch. Since then, Mr. Tong has worked at Jones Day in Los Angeles, first as an associate and then as a partner. His practice focused on appeals and constitutional litigation, and Mr. Tong was appointed as a civil appellate practitioner on California's Appellate Indigent Defense Oversight Advisory Committee. At every turn of his career, Mr. Tong was not only succeeded, but excelled. He's a standout appellate lawyer, and he's a great choice to serve on the Ninth Circuit. Likewise, Mr. Dunlap is a stellar appellate advocate, and our district court nominees are also highly qualified. We'll introduce them after the ranking member makes his opening statement.
Thanks, Mr. Chairman, and I especially appreciate your opening statement related to the publication in Truth Social last night. You have stated publicly that you support the blue slip, as has Senator Graham before you. And I followed that standard as well in the 4 years that I chaired this committee. Maybe it's inside baseball and too much minutia, but it really relates to the relationship between the minority and the majority on this committee and the basic rights that we have given for district court judges to the senators that we serve with. I thank you for saying what you did this morning. When they've asked me about this outside this room, I've said that you have given your word as I have as well, and we'll stand by it. I hope that continues to be the case. I believe it will.
Yes.
Today's slate of nominees represents the latest chosen by the Trump administration. Notably, both of the nominees in the first panel were selected without meaningful consultation with all of their home state senators. At the outset, I'd like to address how Mr. Dunlap and Mr. Tong were selected. For both nominees, the White House did not engage directly with the Democratic home state senators. For the First Circuit vacancy, Senator King was informed 2 months ago the White House was considering Mr. Dunlap. Senator King had no role in submitting or recommending candidates to the White House. Ninth Circuit selection process, the White House engaged with Senators Padilla and Schiff on this vacancy for only 3 months before announcing this nomination. In comparison, the Biden White House discussed 2 Sixth Circuit vacancies and a Fourth Circuit vacancy with home state senators on this committee for 7 months, 9 months, and 6 months, respectively, before making a selection. Beyond the lack of meaningful consultation with Democratic home state senators, there are troubling aspects of these nominees' records which will be discussed this morning. Just this year at a Federalist Society event, Mr. Tong blamed welfare for the, quote, dissolution of the family and questioned the constitutional rights of LGBTQ Americans to get married or even engage in private sexual contact. And Mr. Dunlap was counsel in literally dozens of cases defending Big Pharma for its role in feeding the opioid epidemic that has claimed the lives of hundreds of thousands of Americans. William Mercer, nominated to the District of Montana, played a key role in the U.S. attorney firing scandal during the Bush administration. As a result, his nomination for Associate Attorney General was withdrawn. I would also look forward to hearing Mr. Mercer's explanation for opposing language in the Montana legislature that would have eliminated the statute of limitations for civil lawsuits by survivors of child sex abuse. Mr. Mercer proposed amendments to the bill that survivors called, quote, a total sellout in favor of child molesters and insurance companies. I am relieved that despite his initial opposition, a compromise bill was eventually enacted in Montana. I'm also deeply concerned by Chad Meredith's record. He repeatedly took extreme anti-choice positions while serving as Chief Deputy General Counsel for then Kentucky Governor Matt Bevin and as Kentucky Solicitor General. I want to hear from Mr. Meredith his role in Governor Bevin's controversial pardons of hundreds of violent offenders during his final days in office. Mr. Meredith reportedly, and he's going to get a chance to testify, signed off on the pardon of Patrick Baker, who had been convicted for, quote, pretending to be a U.S. Marshal, robbing a pregnant woman at gunpoint and killing her husband before stealing oxycodone from the victim's residence. Prior to the pardon, Baker's brother held a fundraiser for Governor Bevin, which included a personal conversation with the governor. I fear these nominees, unfortunately, have many questions that need to be answered, and I beg for the patience of this committee in bringing all this information to light.
Senator Collins.
Thank you, Mr. Chairman. Good morning. Chairman Grassley, Ranking Member Durbin, members of this committee, I'm pleased to appear before this distinguished committee today to wholeheartedly support Joshua Dunlap's nomination to serve on the U.S. Court of Appeals for the First Circuit. I do want to explain, given Senator Durbin's comments, how we go about choosing judicial nominees for the federal bench in the state of Maine. We each depending on which administration is in charge, form an advisory committee that interviews individuals who are interested in being nominated. That advisory commission then advises the senator of the same party as the president what their choices are. In this case, Mr. Dunlap was the number one choice of the advisory committee. At that point, the other senator, in this case, Senator King, interviews the individual after the nomination has gone to the White House. 2 nominations or 3 possibilities usually go at a time. And but before the nominee is officially nominated, the other senator from the state of Maine does have the opportunity to interview the nominee. And that is what happened this case. That is what happened in reverse during the Biden administration. So I just want to make clear that there was no change in the way the selection process was handled. Josh grew up in Vassalboro, Maine, and now lives in Scarborough with his wife, Sydney, and their 3 children. If you look in back of me, you will see his 3 children, his wife, his parents, and numerous other members of his family. In fact, 20 of them who are so proud of his nomination that they've made the trip to Washington. Josh graduated first in his class from Notre Dame Law School, where he received the law school's highest honor, awarded to the student with the most distinguished academic record. He then clerked for Judge Paul Kelly of the U.S. Court of Appeals for the 10th Circuit. In 2009, Josh joined the very well-respected law firm Pierce Atwood in Portland, Maine. During his 16 years at the firm, he has specialized in complex civil litigation matters and currently serves as co-chair of the firm's appellate and amicus division. Josh is admitted to practice in multiple U.S. courts of appeal and before the U.S. Supreme Court. He has also assisted special masters in 3 original jurisdiction proceedings before the U.S. Supreme Court. Finally, Josh also chairs the Maine Appellate Rules Committee, to which he was appointed by the Maine Supreme Judicial Court. This impressive experience, coupled with his extraordinary intelligence and integrity, makes Josh exceptionally well qualified for a seat on the First Circuit. His substantial appellate litigation experience will bring a practitioner's perspective to the court. The committee has already received many compelling letters of support for this nominee, and I would like to highlight a couple of them. A diverse group of faculty and alumni of Notre Dame Law School who taught Josh or studied alongside him have praised his, quote, respect for differing views and, quote, deep appreciation for the rule of law. A letter signed by 19 leading Maine attorneys who described themselves as having a broad spectrum of political views and legal philosophies wrote that Josh has all the qualities the finest judges exhibit. He is hardworking, courteous, and judicial in temperament, very smart, and of sterling character with a commitment to fairness and the rule of law. Mr. Chairman, before I conclude, I would like to thank Judge William Kayada, whom Josh has been nominated to replace, for his outstanding service to the First Circuit. I joined in recommending him to President Obama and had the honor of introducing Judge Kayada to this committee. Now it is my honor to recommend Josh, who actually worked with Judge Kayada early in his tenure at Pierce Atwood, to this committee. I am confident that if confirmed, Josh will serve Maine and the nation extraordinarily well in this critical role. For these reasons, I urge the committee to support his nomination, and I appreciate this opportunity to introduce him to the committee. Thank you, Mr. Chairman.
Thank you, Senator Collins. Now Senator McConnell.
Thank you.
Mr. Chairman, distinguished members of the committee, it's my distinct privilege today to introduce my fellow Kentuckian, Chad Meredith. President Trump made an outstanding choice for this nomination to be U.S. District Judge for the Eastern District of Kentucky. Earlier this year, I proudly recommended Chad to the White House, and as you will see from today's hearing, he has the intellect, skill, and experience to excel as a district court judge. One of the Senate's most important constitutional responsibilities is to offer its advice and consent with respect to executive nominations. And like all of you, I take very seriously the responsibilities to carefully consider every nominee, especially from my home state. Chad is a very bright lawyer with a stellar resume and a distinguished record of public service. But I'd like to share with you how I first met him. Chad interned in my office in 2003. The internship program, and I know virtually all of you have the same sort of thing, provides college students with the opportunity to enhance their education as well as increase their knowledge of issues important to the Commonwealth and to the country. We select our interns on the basis of strong scholastic and extracurricular achievements, as well as interest in the government process. And I've been impressed to watch a former Mac intern through the decades succeed in the legal field, public service, and now be nominated to the federal bench. Chad graduated summa cum laude from Washington Lee, summa cum laude from the University of Kentucky College of Law. Following his formal education, he sharpened his legal skills with 2 judicial clerkships with then District Judge Amultha Parr on the Eastern District of Kentucky and Judge John Rogers on the 6th Circuit. He served as the first Solicitor General for the Commonwealth of Kentucky. As the Solicitor General from 2019 to 2021, Chad oversaw all civil and criminal appellate litigation involving the Commonwealth. He earned a reputation for being fair-minded and professional and for having a strong work ethic. From throughout the country, we have dozens of current and former state solicitors general expressing their strong support for Chad's nomination. As Kentucky's first Solicitor General, they said, Chad distinguished himself in diverse areas of federal and state law. Chad also exhibits the temperament necessary to be a district judge. As Chad's professional peers who have witnessed his work, we're confident that he possesses the qualities to serve with distinction as a district judge. That's from the other solicitors around the country. Additionally, it's quite notable to hear from hundreds of lawyers calling Chad fair-minded. These lawyers come from many diverse backgrounds, include civil litigators, prosecutors, and criminal defense attorneys. They hold various political views and judicial philosophies and are supporting this nomination, saying, we all agree that our legal system needs judges who carefully and honestly evaluate the arguments made by the parties and do what the law requires. We all believe that Chad will excel as a district judge. Amid Chad's great professional success in private practice, even his colleagues know his value as an excellent lawyer and a careful thinker will serve our nation well. As much as we don't want to lose him, our loss would be the public's gain. This is all very resounding support, and where that support runs deepest is with Chad's family, who are here. I'd like to recognize his father, Kentucky State Senator Steve Meredith, and his mother, Karen. They're both here, and I know they're very proud of Chad, and so is his wonderful wife, Rebecca, and we can bet that each of their children, Ben, Grace, Emma, and Daniel, are beaming with pride for their dad. Also joining today to support Chad's commitment to public service is Kentucky State Representative Samara Hebron, as well as many more members of his family, his friends, and colleagues. So, Mr. Chairman, thank you for the opportunity to come by and put in a good word. I'm confident that Chad Meredith, who has demonstrated devotion to the rule of law and the Constitution, will serve the people of Kentucky and our country well on the federal bench. Appreciate the opportunity. Look forward to his confirmation.
Thank you, Senator McConnell. Now, Senator Daines.
Chairman Grassley, thank you, as well as to Ranking Member Durbin. It's an honor to be here today with you all to speak in support of my friend, Mr. William Mercer, and his nomination to serve as the next judge of the U.S. District Court for the District of Montana. Bill's a lifelong Montanan, born in Billings. That's where my dad and mom actually met. My dad married the girl next door. That's where Bill was also born. We were actually high school rivals. Bill was a Golden Bear from Billings West High School, and I was a Bozeman Hawk. We debated each other in speech once upon a time. I've known Bill a long time. He went on to receive his undergraduate degree at the University of Montana, and then on to Harvard, where he received his Master's of Public Administration. He received his law degree from George Mason. Bill has served Montana's country in various roles over the past 3 decades. In Montana, he served as U.S. Attorney for the District of Montana from 2001 to 2009, as a representative Billings in the Montana House of Representatives for the past 7 years. At the U.S. Department of Justice, Bill served as Principal Associate Deputy Attorney General and Acting Associate Attorney General during the George W. Bush administration. He's also been actively engaged in his community, serving on 5 nonprofit boards of directors in Montana. He's been a member of the Montana Bar for 32 years. He has appeared in state and federal court in Montana in numerous civil and criminal cases as the lead counsel. He's also represented clients in appellate courts, which resulted in oral arguments in 15 cases in the courts of appeals for the 9th Circuit, D.C. Circuit, and the Montana Supreme Court. Bill's been recognized by his peers in the legal community for his outstanding track record, being rated among the best lawyers in Montana for environmental and commercial litigation. Throughout his extensive legal career and years of public service, Bill has represented Montana's interests very well. He is committed to the rule of law and the original interpretation of the Constitution. Bill understands Montana-specific laws and issues. His experience as a widely respected and effective member of the Montana House of Representatives brings him in tune with the needs of our state, our families, and our communities. I believe his time serving in Helena has given him an important additional perspective on the law and the importance of judicial impartiality. Senator Tim Sheehy and I are confident Bill is the top choice to once again serve Montana, this time as our federal judge. We take this responsibility very seriously. As we know as senators, these are lifetime appointments and require careful consideration. His time at the Department of Justice as U.S. Attorney and as a state legislature have prepared him well, and I can't think of a better pick to represent us once again in this new role. I look forward to working diligently with my colleagues to confirm his nomination, and I want to thank this committee for its consideration.
Thank you. Senator Padilla for 3 minutes.
Thank you, Mr. Chairman, and Ranking Member Durbin for giving me the opportunity to share my serious concerns about one of today's nominees. Eric Tong was chosen for this lifetime position because of his extreme conservative ideology and its association with the conservative Federalist Society. The White House selected him despite clear communication from me and from Senator Schiff that he was an unacceptable choice, and despite our putting forward names for the White House to consider for candidates, both of whom are Republican judges previously nominated by President Trump to the district court. But that's not why I'm opposed to Mr. Tong's nomination. I'm opposed because Mr. Tong believes in a conception of the Constitution that rejects equality and liberty, and that would turn back the clock and continue to exclude vast sections of the American public from enjoying equal justice under the law. In just the last few years, we've seen what extreme conservative ideology has done to erode public trust in institutions like the judiciary, including and especially the Supreme Court. As long-established legal precedents have taken a backseat to whatever novel conservative legal approach accomplishes the desired political outcome. By continuing to confirm extreme ideologue to the federal bench, the Senate would be doing California and the American people a deep disservice. The people of the Ninth Circuit deserve judges who believe in gender equality, in equal rights for LGBTQ plus people, judges who believe that the First Amendment applies to speech they personally dislike as much as speech they support, and who believe in the principle of the separation of church and state, and who believe in protecting our workforce. That is not Eric Tong. But in addition to his partisan ideologies, we can also talk about his narrow legal experience. For those watching at home, an appellate judge's role is to hear appeals that arise from decisions of lower courts. That's why it's so vitally important that appellate judges have experience not just with appeals, but with trial litigation. Mr. Tong has none. He has never served as the sole or lead counsel in a case tried to verdict or to judgment from the bench. And he himself estimates that only 10% of his work has been on criminal cases. And it's also important to acknowledge the larger moment that we're in. During the first 6 months in office, President Trump has mounted a historic attack on our nation's justice system. He's tried to remake the Department of Justice and even the federal bench in his own image, rewarding those who have demonstrated their loyalty to him over the rule of law. That's true of his Attorney General pick, of his Deputy Attorney General pick, of the FBI director, and more recently to reward even more of his own personal lawyers with roles like U.S. Attorney for the District of New Jersey and even a federal judge on the Third Circuit Court of Appeals. He's gone around the Senate's advice and consent role for the U.S. Attorney's pick in both New Jersey and New York, and now in my home state of California. So I can't wait to get to the questions segment of today's hearing, but I will tell you right now, colleagues, I strongly oppose this nomination and urge you to do the same. Thank you, Mr. Chairman.
Senator Schiff for 3 minutes.
Thank you, Mr. Chairman and Ranking Member Durbin. One of the opportunities I was looking most forward to when I was elected to the Senate was the chance to work with the White House, including under Republican administrations, to select good nominees for the federal bench in California and beyond. Unfortunately, that optimism didn't last very long. I was disappointed by the White House's failure to work with Senator Padilla and myself to select an appropriate and mainstream nominee to the vacant Ninth Circuit Court of Appeals seat in Pasadena. Instead, President Trump decided to appoint Eric Tong, someone who is and has expressed vehemently anti-labor, anti-collective bargaining ideas and once organized a protest against Labor Day. As a U.S. Senator from California, that is particularly concerning for a state where Cesar Chavez and Dolores Huerta made such a principled and celebrated stand for working people. Mr. Tong has been a proponent of dangerous legal arguments like the independent state legislature theory, a theory so fringe that even this Supreme Court ruled against the position he took in 2023 by a vote of 6-3. That case, which conservative scholar and Judge Michael Ludwig described as the most important case for American democracy in the almost 2.5 centuries since America's founding. That we would have someone who would take such a dangerous and fringe position in a case of that seminal importance to our democracy is deeply alarming. Mr. Tong has said that he believes in gender roles and that as an originalist, he disagrees with current Supreme Court precedent recognizing a constitutional right to same-sex marriage and same-sex couples' right to privacy. The White House, I think, missed a real opportunity to work with Senator Padilla and myself to identify a candidate who could garner bipartisan support in this fragile moment. We were prepared to and have tried to work in good faith despite the many attacks that we have endured from the White House against Senator Padilla and myself. Just this week, the Attorney General announced that her department had filed a misconduct complaint against the sitting federal district court judge because he ruled against the administration and has issued an order to show cause why the Justice Department should not be held in contempt. The merits of which now multiple whistleblowers have filed complaints, and this action by the administration to penalize a judge, holding hearings into whether orders of his court were violated, demonstrates, I think, the danger to the rule of law and the importance of making sure that we confirm judges who will prioritize obedience to the rule of law and not just obedience to the President of the United States, the person of the President. And now more than ever, we need federal judges who will protect the rule of law. So I join Senator Padilla in expressing my grave concerns about Mr. Tong. I look forward to this hearing and the opportunity to question him about his loyalty to the President and whether that takes priority over obedience to the law. And I yield back.
Mr. Tong and Mr. Dunlap, please come forward and stand so I can swear you in. Do you swear that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Both responded affirmatively. Now please sit, and before you give your statement, if you want to introduce family and friends, you have the right to do that. And I'll start with Mr. Dunlap.
Thank you, Chairman Grassley, Ranking Member Durbin, members of the committee, for the opportunity to be here today. And it is an honor to be here. Of my 4 grandparents, only one went to college. My 2 grandfathers, with only high school educations, built their own small businesses from the ground up. I think they would be proud today. There are many people that I would like to thank. Time allows only a few. First, I'd like to thank President Trump for the honor of this nomination. Second, I'd like to thank Senator Collins for her warm support from the very outset of this process. Most significantly, I'd like to thank my wife, Sydney, for her tireless love and support throughout this process. I would not be here without her. I'm thankful that she is here with me today, along with my 3 children. They are my world. I wish I could mention all of my extended family who are here with me today. I cannot do that, but I am so deeply grateful that they are here and showing their support. I would be remiss if I did not mention my parents, Frank and Colleen Dunlap, for the sacrifices that they made over the years to make today possible. I recognize that I am here today standing on the shoulders of those who have come before me. I want to thank my many mentors, in particular Judge Paul Kelly of the U.S. Court of Appeals for the 10th Circuit. And to my many friends and colleagues at Pierce Atwood, thank you. I have learned much from you. It is my sincere desire, should I be confirmed, to serve my state and country well by upholding the rule of law. Thank you.
Thank you, Mr. Dunlap. Now, Mr. Tong.
Chairman Grassley and Ranking Member Durbin, it is an honor to appear before you and the committee today. I would like to begin by thanking President Trump for his nomination of me to serve as a judge on the 9th Circuit Court of Appeals. It is truly an honor of a lifetime. I am blessed to have my parents here in attendance. I am indebted to my mother and father in every way, and am thankful to be with them here before this august body. I thank my brother, too, and my aunt and uncle for coming from Santa Monica to be here. I am also very happy that my in-laws could make it from Georgia, Massachusetts, and Virginia, including my mother-in-law, sister-in-law, brother-in-law, my wife's aunt and uncle and cousins, and my wife's grandparents. Finally, I'd like to acknowledge my wife, the love of my life and my best friend. Her support is indispensable and means everything to me. Our 7-month-old son sends his regrets for not being here today. We live in the greatest country on earth, with a legal system that is the envy of the world. Our founding fathers and the framers of our Constitution pledged their lives and fortunes to bestow upon us a system of government that has proven to be the best guarantor of our liberty and the rule of law. Generation after generation, ordinary men and women of heroic virtue and love of country have stepped up to carry out the promise of our great republic, to prove to the world and their posterity that this grand American experiment of self-government could not only survive, but flourish. We stand on their shoulders, and we owe it to them and ourselves to preserve what they have passed on to us. Justice Antonin Scalia and Justice Neil Gorsuch, two of our country's greatest jurists, have carried on that tradition. A student of their jurisprudence, I had the honor of serving as a clerk to both justices on the United States Supreme Court. From them, I learned firsthand about what it means to be a judge, the importance of construing the Constitution and the laws of this country faithfully, without fear or favor, of putting aside one's own politics or subjective views when interpreting the law as passed by Congress and as understood by the people. Ninth Circuit Judge Sandra Ikuta, whose seat I have been nominated to fill, is also one of the finest jurists to serve in our judiciary. If I am so fortunate to be confirmed, I will do my best to serve ably and honorably as they have. I welcome the committee's questions.
Thank you. I will start with 5 minutes for everybody. I've been asked to be a little more firm on people staying within the 5 minutes, so if you hear the gavel lightly, please observe it, because we're trying to help each other out. Mr. Tong, you already spoke about the justices that you served under, and you told a little bit about it, but I want to give you an opportunity if there's something you have said that you learned from them. What did you take away from those clerkships about the role of a judge in our constitutional system, and how have those lessons shaped the way you approach legal questions today?
Thank you for the question, Chairman Grassley. Justices Scalia and Gorsuch were masters of the judicial craft, and I learned immensely from them about how to be a judge. The analytical rigor that they brought to their jurisprudence was something I took away from the job. Their writing styles, their ability to communicate and convey ideas crisply and succinctly was something I also learned from them while I was a clerk. There was one experience I had when I clerked with Justice Scalia, and as a law clerk, I tried to be too clever by half and included in a draft a Latin phrase. Justice Scalia read it, and he told me, "Eric, I think there's a grammatical error in the Latin phrase you inserted." And he walked across his chambers, pulled out from his drawer a magnifying glass, got out a Latin dictionary. The font in the Latin dictionary was extremely tiny, and looked up the phrase, and lo and behold, there was a grammatical error. From that experience, I learned how careful and diligent he was in his approach to the law, and I hope I can carry that with me as a judge on the Ninth Circuit if I am so lucky to be confirmed.
Thank you. Now, Mr. Dunlap, you were selected by the Maine Supreme Court for the Advisory Committee on Maine Rules of Appellate Procedure. You've served as a committee chairman since 2023. What have you learned from your time advising the state of Maine on appellate rules, and how will the experience serve you if confirmed as a judge for the First Circuit?
I think one of the things that we have discussed on a number of occasions is making sure that the rules are understandable and accessible to individuals who may be proceeding pro se. For state courts, that is a significant consideration. I believe that reflects an important premise that the law should be available to all and that the law should be impartially and fairly applied to every litigant who comes before the court. And that is certainly something that I would seek to do should I be confirmed.
Thank you. Now back to Mr. Tong. You've clerked at nearly every level of the legal system and working with the Bristol Fellow at the Solicitor's Office to prosecuting federal cases as an assistant U.S. attorney, and now you're in private law practice. How has that wide-ranging experience prepared you to take the responsibilities of a federal appellate?
Chairman Grassley, my time in public practice and private practice has well equipped me to serve as a judge on the Ninth Circuit. I've handled numerous appeals in both federal and state courts of appeals. I've briefed and successfully prevailed in various cases on both the appellate levels and the trial court levels, again, in both federal and state courts. I have also assisted several trial teams in serving as an appellate strategist in helping to preserve appellate issues and preparing witnesses. I've also drafted several proposed jury instructions in those matters as well. I've appeared before judges in detention hearings and also motions to suppress. And in my time at the Office of the Solicitor General, I got to handle some of the most high-profile cases that have come before the U.S. Supreme Court. I assisted the assistants to the Solicitor General, as well as the U.S. Solicitor General, in crafting briefs, in developing arguments, in conducting legal research, and in assisting them in their oral argument preparations.
Mr. Dunlap, I have 27 seconds left. That doesn't account for your answer, but you filed an amicus brief on behalf of the Conference of Chief Justices. It's a quote, I'd like to quote, that this is the highest judicial officers of each state and U.S. attorney. The primary focus was on federalism. What are your views on federalism?
It was an honor to be able to represent the conference in that case. I think federalism is a part of our structure of separation of powers that is important to our system of government, that powers are not only separated horizontally, but also vertically, and that provides a second guarantee to the rights of the people.
Thank you. Senator Durbin.
Mr. Dunlap, Mr. Tong, and your families, welcome. We have 5 minutes to ask questions to determine whether or not you will receive a lifetime appointment to the second highest court in the United States of America. It's hardly enough time to reflect on anyone and to measure what they believe and to make some decisions about that information. What I'm going to do is basically refer to things that you've done or said and ask you to give us, in all honesty and candor, response to the questions about them. Mr. Tong, in a 2004 speech, you were responding to a 2004 speech by then President of the National Organization for Women. You said, and I quote, "I believe in emphasizing family and what it means for a woman to be a good wife or partner," end of quote. You added, and I quote, "I believe in gender roles and that women are simply better than men at some things. When these radical feminists try to blur gender roles, they undermine institutions like marriage, institutions which hold society together," end of quote. It doesn't appear that your views, Mr. Tong, have changed much over the years. Just months ago, in remarks for the Federalist Society, you defended originalism and wrote, and I quote, "Whether there's a constitutional right to abortion, same-sex marriage, sodomy, pornography, transgender procedures, the answer for the originalist is simple: no," end of quote. This wasn't a youthful indiscretion. Your speech was just given a few months ago. You seem to be questioning landmark Supreme Court decisions like Lawrence versus Texas and Obergefell. Let me ask you point blank. Do you believe there's a constitutional right to marriage for same-sex couples?
Ranking Member Durbin, the Supreme Court's decision in Obergefell versus Hodges has granted such a right, and as a circuit judge, if I were so lucky to be confirmed, I would be bound by that precedent.
Do you still believe in gender roles?
Senator, those comments that you're referencing occurred over 20 years ago when I was an undergraduate in college. I was responding to a speaker who was invited to come speak on gender-related issues, and at the time, I found her views to be extreme in that she portrayed the relationship between the sexes of male and female to be antagonistic, and that she was blurring the gender roles. And I was responding to that in those comments that you quoted, because I believed at the time that the relationship between men and women were complementary and that the family should be strengthened.
What do you believe now?
Senator, when it comes to live issues, I, under the canons of judicial ethics, cannot comment on that.
See, that's where we run into problems. When we get down to basic values and positions, we know what he's written years ago. I asked him what he believes today, and he says he can't tell me the answer because he's possibly going to be on the bench. So it's very difficult to really understand where you stand on this situation. Mr. Dunlap, in March 2015, you submitted written testimony to the Maine legislature in support of a bill that would have made it more difficult for minors and incapacitated people to access abortion. The bill you supported sought to change Maine's law, which does not require minors to obtain consent of a parent or guardian before having an abortion. So let me ask you, today, should a minor who is sexually assaulted or a victim of incest be forced to give birth if her parents do not consent to her having an abortion?
The testimony that you are referencing would have brought Maine's laws into line with the laws of states such as Massachusetts and Rhode Island. It is also consistent with laws that the Supreme Court had upheld in Planned Parenthood versus Casey. My own views are not relevant to the job that I would have should I be confirmed to the U.S. Court of Appeals for the First Circuit. I would faithfully apply binding precedent as well as any laws that I was required to interpret.
So let me ask you, are you saying that what you said on in March of 2015 is the same position you hold today or a different one?
My personal policy preferences, again, Senator, are not relevant to the work that I would do. What I would seek to do is to fairly and impartially apply the law to every litigant who might come before me in a particular case or controversy.
And what about the precedent in Obergefell?
That would be binding precedent should I be confirmed.
Let me ask a question of you, Mr. Dunlap, related to a gentleman by the name of Mike. I'm sorry, this is for Mr. Tong. A gentleman by the name of Mike Davis, who posted on social media, quote, Eric Tong is a friend who will continue Trump's historic inroads in once left-wing Ninth Circuit. Mr. Davis is the president of right-wing Article 3 Project, and according to public reporting, he's played a key role in advising President Trump on judicial nominations during his second term. Is he your friend?
Ranking Member Durbin, Mike Davis is my friend.
Do you have any conversations with him regarding your nomination before President Trump announced it on July 2nd?
Just simply that it happened, Your Honor, Senator.
Mr. Davis has made overtly racist remarks on numerous occasions. For example, in October of 2023, he wrote in a social media post, quote, the violent black underclass is a danger to America, and quote, these monsters will kill. Do you agree with or condemn this offensive statement by Mr. Davis?
Ranking Member Durbin, the views expressed by Mr. Davis are not necessarily my views and vice versa.
Senator Lee.
Thank you very much, and I appreciate your willingness, both of you, to serve and to be here. You both come with impressive qualifications, and I very much look forward to working to secure your confirmation. In each of your cases, you come with a strong set of recommendations and great professional experience to back that up. And both of you, as far as I can tell, come with a built-in understanding of the necessarily limited but indispensable role that our federal court system plays. There are a lot of misunderstandings about what the federal courts are. They are not there to adjudicate hot-button social disputes. They are not there to serve as representative bodies. They're there to decide discrete questions of law presented before them, where two or more parties disagree as to the meaning of the law and where the law needs to be enforced or in one way or another applied. But they're there in a sort of rear-view mirror capacity to decide what the law is, what the law says, what it said, and what the original understanding of those words were, based on the public meaning at the time of enactment if a statute or the time of ratification if a provision of the Constitution. Mr. Tong, let's start with you. As a federal judge, federal appellate court judge, if confirmed, which I very much hope you are, you'll be required to interpret the text of federal law across a broad range of topics, including provisions of the U.S. Code, including provisions of the Constitution. How will you approach this task? And what sort of judicial philosophy would you say guides your interpretive approach as a judge?
Thank you for the question, Senator. I would start, as instructed by the Supreme Court, I would start with the text of the statute that's being interpreted, or if we are interpreting a constitution, the particular provision of the Constitution. If the text does not yield a clear answer, I would move to the context or the structure of the statutory provision. That is, looking at the surrounding provisions that may shed light on the meaning of the provision under issue. Beyond the context, I would look to the history, what animated the passage or the enactment of the law. And precedents, of course, that bear on the meaning of the text would be consulted carefully as well. And I would also apply various statutory canons of interpretation if, again, the issue before me is a statute.
What role, if any, would legislative history play there? And by legislative history, I mean not sort of the sequence in which things were added, but rather more directly committee reports, floor statements by individual members, either on the Senate floor or in committee.
Senator, legislative history is not law. It didn't overcome the bicameralism requirements that are set forth in Article I, Section 7 of our Constitution. I would, again, look to the text.
Now, speaking of Article I, Section 7, there are two fundamental elements that have to be satisfied in order to make a new federal law or modify an existing federal law. Those steps are bicameral passage followed by presentment. You referred to those briefly a moment ago. In your view, what are the dangers of ignoring that? And to what degree do you think we've gotten a little too fast and loose with the way we approach Article I, Section 7?
There's a grave danger in ignoring the bicameralism and presentment requirements as set forth in Article I, Section 7. The founders designed the Constitution in a way that would give accountability to the people, ultimately. Our powers under the Constitution, the government's powers, are derived from the people. And so under Article I of our Constitution, the Congress was divided into two houses, so requiring both the House and the Senate to pass by a majority vote the bill that's being under consideration. Now, the president also needs to agree and sign and provide his approval in order for that law to become in the U.S. Code. So I believe that bicameralism requirement is extremely critical to our constitutional system.
The requirements of bicameralism and the requirements of bicameral passage followed by presentment of the president were deemed not to have been satisfied in INS v. Chadha, and on that basis, the legislative veto provision in that case, and ultimately in all other cases, were deemed unconstitutional as violative of Article I, Section 7. If it is the case that you have to ring the legislative bell in order to make a new federal law or change an existing federal law, and if it is the case that that wasn't satisfied in INS v. Chadha, where the application of an existing provision of federal law was being changed or modified in that instance, in some cases by one chamber, in other cases by both, but without the added step of presentment to the president. Couldn't one also make the same argument that where the obligations imposed on members of the public by a federal statute or by a provision of federal law, let's say a federal regulation, where the obligations inherent in that affirmative command to the public aren't evident on the face of the underlying statute authorizing the promulgation of that reg, couldn't that arguably be said to violate Article 1, Section 7, just as the legislative veto was in INS v. Chadha?
Senator, it could arguably pose an issue under Article 1, Section 7. It also poses an issue under the non-delegation doctrine, which is derived from the vesting clauses of our Constitution. Article 1 says that all legislative powers granted herein are vested in the legislative branch, are vested in Congress. And so Congress can't delegate its lawmaking powers to an unelected federal agency to make laws. And so I believe it would pose a problem potentially under the bicameralism presentment provision, but also under the non-delegation principle.
Senator
Wonderful.
Padilla.
Thank you.
Thank you, Mr. Chairman. Colleagues, I want to follow up on an issue and comments that were raised by Ranking Member Durbin, because I've had the opportunity to take a look at Mr. Tong's background. We've had an opportunity to have a conversation via Zoom. And I know he has strong views about how other people's families should function and what women should be allowed and not allowed to do. I'll quote from Mr. Tong's previous writings. He has criticized the so-called, quote, welfare state for the, quote, disillusion of the family, end quote. He has said he, quote, believes in emphasizing family and what it means for a woman to be a good wife and partner, end quote. He has said, and I find this reprehensible, that he, quote, believes in gender roles and that women are simply better than men at some things. When these radical feminists try to blur gender roles, they undermine institutions like marriage, institutions which hold society together, end quote. Mr. Tong, can you list for us the things that you believe are, quote, simply women are, quote, simply better at than men?
Senator, again, the comments you're referencing and captured by a Yale Daily News reporter were captured over 20 years ago when I was an undergraduate in college.
Yes, I understand that, but that was 2006, not 1956. Even the year 2006, I don't think the country's mood, let alone the law, was what you're suggesting here.
Senator, my wife is sitting behind me, and I can tell you that she is better at many things, and not just some things, than I am. She worked on the Hill, she worked in the White House, and she worked for a Fortune 1 company.
So then do you still believe that women should stay home and not go out into the workplace?
Senator, the suggestion that I think women should not be provided with the same professional opportunities as men is inaccurate.
So at what point in the last 20 years, not 50 or 60, just in the last 20 years, did your mind change on this?
Senator, my views on policy matters and sociological matters that you're referencing, again, are the subject of wide debate. And for that reason, as a nominee sitting here today before the committee, I cannot
But there's a
answer
couple of
under
reasons I
judicial
bring
canons.
this up, and there are some other issues I want to get to. But first of all, I think for any person to come into a courtroom, they deserve to know that they're going to be given a fair trial, fair consideration in a proceeding. So given your very public past comments, not long ago history, relatively recent history, how should a woman be entering into your courtroom thinking they're going to get a fair shake if you won't even tell us when and how your mind was changed on this? And you've now referenced twice this concern about live issues. So what item is working its way through the judiciary that may well appear on the Ninth Circuit for you to consider and rule on?
Senator, every litigant who would come before my court, should I be so lucky to be confirmed as a judge, would be treated with, man or woman, would be treated with equality, dignity, and respect.
Well, that's why we're asking this question. But what are the live issues that you're referencing that keep you from answering Senator Durbin's questions and my questions?
Senator, matters of policy and of sociology.
What is the live issue you're referencing that's keeping you from answering Senator Durbin's question and my question?
Senator, I apologize, I'm not understanding the question.
Well, you are hiding behind a, quote, live issue concern for not answering Senator Durbin's question or my question.
Senator, the live issues that you're referencing are based on certain comments.
I want to know
that
what
I've
you're
made.
referencing.
Senator, the live issues that I'm referencing are matters of policy and sociology that impinge on gender-related issues.
So anything that could be a topic of conversation anywhere in the country at any time will keep you from answering our specific questions. Let me move on to one more item then. Because you've been a prolific writer, not just on your views about women, but on views on American workers. My colleague, Senator Schiff, raised an incident, a Labor Day protest that you were one of the leaders of you were president at the time for the Committee for Freedom. The protest in question, protesters there had a message, quote, "End mandatory maternity leave. It hurts women." Others held signs that said, "Workers of the world, get back to work." And Mr. Tong specifically wanted to tell the Yale campus that unionized labor hurts consumers. Mr. Tong, is this you holding a sign that says union no?
Senator, that is me from over 20 years ago when I was in college exercising my First Amendment rights.
Absolutely, and I defend your First Amendment rights, but I also defend labor rights and labor protections in this country. So just as I asked with women a few minutes ago, if a labor issue is before you, how can working men and women come into your courtroom and feel like they're going to get a fair shake given your clearly strong views, not in the long ago past, but in the relatively recent past?
Senator, when one puts on the robe, the person's role changes qualitatively. And I can assure this committee, and I commit to this committee, that if I were fortunate to be confirmed as a judge, I will evaluate each argument advanced by the parties respectfully, carefully, and with the scrutiny that it deserves.
Do you recant this and your other comments that I've cited here today?
Senator Brett.
Senator, again, live issues on policy, I cannot comment.
You do not recant.
Judicial
Thank you.
canons.
Mr. Tong, and thank you both for being here. I'd like to give you an opportunity to talk about your wife again. I heard what you said about her. I know what it means to be in a partnership. And I would hope that if my husband was asked, he'd have a long list of things that I am better at than him. But will you tell me a little bit about your wife and her accomplishments? And I'd love to hear it.
My wife is the most beautiful woman in the world.
Love it.
She is one of the most professionally accomplished women that I have ever met. As I mentioned to Senator Padilla, she worked on the Hill. She worked in the White House for President Trump during his first term.
Which for all of you know, the staff around here is where things really get done. So thank you.
And she worked for a Fortune 1 company.
Wow.
In the executive speech
Sounds like an accomplished woman, both just throughout her life.
Thank you, Senator. I could not be prouder of my wife.
Well, I'm certainly proud to hear you talk about her as well. Thank you. I want to talk to both of you about something you've previously expressed, and that is originalist and textualist interpretation. I know that this is an ongoing debate. Is it the, same thing? Is it different? Is it distinct? Are they related? How does this work? I'd love to get your thoughts on that methodology and your views on kind of how those terms should be defined and then what role they will play for you on how you approach things before you on the bench. So we'll let you go ahead first, and then we'll go to Mr. Tong.
I think that they're best understood, originalism and textualism, as two sides of the same coin. As I understand it, it requires a jurist to look into the original public meaning of a text, whether it be a constitutional provision or a statute. And so you would seek to apply a law in the manner that a reasonable person would have understood it at the time that it was adopted when you view it in full context. And so that is the approach that I would seek to bring to the bench, should I be confirmed, in order to keep my decisions firmly grounded in the law.
So real quick, obviously Senator Lee asked Mr. Tong about this, but Article 1, Section 7 in legislative history. Give me your thoughts on that.
There are, of course, Senator Lee's question suggested there are different types of legislative history. Some drafting history is much more objective and useful to a court. But the question, as I recall, was directed to subjective statements of individual legislators.
He specifically mentioned floor speeches, et cetera.
And that, to me, is not particularly persuasive because, as was previously alluded to, it did not go through the bicameralism and presentment requirements, and it goes more to a subjective intent rather than an objective meaning.
So, Mr. Tong, do you support originalist, textualist interpretation? And if so, if you can give me that quick definition and then how you arrived at that conclusion that would be the most appropriate methodology if in fact you believe that.
Thank you, Senator. So I do subscribe, Senator, to originalism and textualism. As Mr. Dunlap so articulately stated, originalism is a method of interpretation of the Constitution that looks to the original public meaning of the specific provision at issue. Textualism addresses the method of interpretation with respect to statutes, but both methods are aimed at the same thing. What did the words mean at the time that they were enacted or ratified? And I subscribe to that view because veering away from that view turns judges into policymakers. No longer are they grounded and anchored in the text, but rather they would be indulging in their own personal policy preferences, and I don't think that's the role of
Which
the judge.
you've said time and time again today, your personal preferences aren't what you're going to take to the bench. So thank you. I strongly believe the federal judiciary has a vital role in protecting religious liberty and freedom. I have been heartened by the Supreme Court's religious liberty jurisprudence in recent years and would like your thoughts regarding the role of the judiciary in defending religious freedoms for all Americans.
Senator, the Supreme Court plays a very important role in defending religious liberties. The First Amendment of our Constitution says it right there. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Supreme Court has faithfully interpreted that provision recently.
Thank you, and in my remaining time.
I would agree. The courts have the responsibility to apply each of the amendments to the Bill of Rights. The First Amendment and the free exercise of religion and the Establishment Clause have been observed to be first freedoms. Those are binding upon the court and should be equally applied for all Americans.
Well, thank you both for your willingness to serve. You're incredibly accomplished and look forward to getting you on the bench.
Mr. Tong, you just said that you're originalist and a textualist. So let me ask you, the Emoluments Clause provides that no person holding public office shall accept any present of any kind, whatever, from any king, prince, or foreign state. Do you believe the language in the Emoluments Clause that says any present of any kind, whatever, means any present of any kind, whatever?
Senator, you are quoting the text of the Emoluments Clause, and I cannot dispute with the text of the Emoluments Clause.
So it would apply to any present, including an airplane?
It would apply to the president, I believe, your Senator.
And I take it as an originalist, you would accept that the founders would have never subscribed to the idea that a president in their time could have accepted a multi-$100 million gift from a foreign state?
Senator, the premise of your question implicates live issues in the public and pursuant to the canons of judicial ethics.
Well, let me just ask you, would the founders have believed that if a president received 100 camels from a foreign state, that was an emolument?
Senator, it's difficult to answer that question in the
Is it, though, as an
abstract.
originalist? Isn't it pretty simple? You've got the clear language of the Constitution.
Senator, one has to look at the language, but also the history surrounding the Emoluments Clause in order to discern the
I am
meaning of
looking
it.
at the history. Let me move on to another question. As an originalist, do you believe that the Obergefell versus Hodges decision affirming constitutional right to same-sex marriage, was that wrongly decided?
Senator, Obergefell versus Hodges is binding precedent of the Supreme Court.
I'm aware of that. Do you believe it was wrongly decided?
Senator, as a circuit judge, I would be bound to follow
I understand that, but that's not responsive to my question. Had you been on the Court of Appeals prior to that decision, would you have decided the case that way?
Senator, prior to Obergefell versus Hodges, there was a prior Supreme Court case addressing the issue, and I would have followed that case.
Well, would you have reached the same conclusion as the Supreme Court in Obergefell?
Senator, I would have followed binding precedent.
You're not
prior
answering
to
my question. Would you have reached the same conclusion?
Senator, the conclusions that the two precedents reached were potentially in conflict, and I would have to follow the precedent that...
So you can't tell us at this point whether you would have reached the same conclusion as the Supreme Court in Obergefell. So let me ask you about the Supreme Court's decision in Lawrence affirming a constitutional right to be intimate among same-sex couples. Do you believe that was wrongly decided?
Senator, Lawrence versus Texas is a binding precedent of the Supreme Court.
Again, I'm aware of that, but I'm asking you whether you believe that was rightly decided or wrongly decided.
Senator, you're asking about my personal views.
No, I'm asking you about your legal views. I'm asking about your legal views. Let me ask you about another case. Do you believe that Loving versus Virginia, which affirmed an interracial couple's right to marry, was that wrongly decided?
Senator, my wife and I are an interracial couple, and so if that case were wrongly decided, I would be in big trouble.
Okay, so you do agree with the reasoning of that case, and you're willing to say that. I appreciate that. But you're unwilling to say that you agree that Obergefell and Lawrence were correctly decided. Why is that?
Senator, again, those decisions are binding precedent of the Supreme Court, and I would be bound to follow.
No, I'm aware of that. So is Loving. And you're willing to tell us that you believe Loving was correctly decided, but you're not willing to say the other decisions were correctly decided. That seems less originalist and more situational. Let me ask you this about your role in the brief in Moore versus Harper. This was a case involving the discredited independent state legislature theory, which would allow a state legislature, even in the absence of a governor's signature, to effectively overturn an election. Do you believe that the Supreme Court wrongly decided Moore v. Harper when it rejected your view?
Senator, again, Moore v. Harper is binding precedent of the Supreme Court.
Yeah, no, I get that, but you're still not answering my question. So let me ask you a different way. If a state legislature decided after an election to pass a bill, even in the absence of a governor signing it, to throw out absentee ballots that were mailed prior to the election but arrived after the election, would it be your view that a state Supreme Court or federal court would have to allow the legislature to overturn the election, would be powerless to correct that effort to overturn a free and fair election?
Senator, Moore versus Harper states that state courts can review what the state legislatures have passed as a matter of the Constitution.
No, I'm aware of that. And my concern, though, is that your unwillingness to embrace the reasoning of these decisions means that where there is room, and there is room in all of these decisions, and most particularly Moore v. Harper, for you as a Court of Appeals judge to narrow these decisions, it sounds like you'll take that opportunity to narrow those rights. And in the case of Moore, which I agree with Judge Luddick, the most important case to our democracy in a century, narrowing that decision means empowering state legislatures to overturn election results, and I cannot imagine a more dangerous idea on the bench. I yield back, Mr. Chairman.
Congratulations, gentlemen. Mr. Tong, you were asked about some of the things you said back in college. And one of the things that you were asked about was a statement you made in 2004. I believe that women are simply better than men at some things. Did you say that?
I did say that, Your Honor, Senator.
You said that you believe that women are better at some things, right?
That's right, Senator.
You didn't say women are worse at some things, did you?
I did not say that, Senator.
Just want to be sure I understand. How is that denigrating women?
It was not denigrating women, and I did not intend it to be so, Senator.
Yeah. I mean, you said they're better at some things. If you said they were worse at some things, you would be denigrating women, wouldn't you?
I would, Senator.
I don't know if I asked you this, but you didn't say they could do things worse. You said better, right? Just want to be sure I understand.
That's right, Senator.
Does government have free speech rights?
Government does have free speech rights.
How so? The First Amendment doesn't mention government, except to the extent that government, it is there to protect, for government, for us to have protection against government restricting our speech. How can government have free speech?
Senator, you are right to the extent that the First Amendment refers to Congress. Congress shall not make any law abridging the freedom of speech or of the press. But there is a government speech doctrine that allows the government to convey a political message it wishes to, and the government is not committed to a policy of neutrality at all times.
Have you ever been to Boston?
I have been to Boston.
Okay. You seen the Boston City Hall?
I believe I have, Senator.
There's a plaza in front, and there's some flagpoles. And Boston, when different groups are having protests or demonstrations or rallies on the plaza, allows those groups to fly their flag. Someone wanted to fly a Christian flag, and the city of Boston said no. And the Supreme Court and the city of Boston said, that's our choice. That's government speech. We don't want to fly a Christian flag. So how come the Supreme Court said that they had to fly the Christian flag if government has free speech?
Senator, if the government opens up its plaza to all comers, so to speak, then it's restricted under the public forum doctrine in terms of what viewpoints it would decide to favor or not.
That's not necessarily so, is it, Counselor? I mean, let's suppose Texas, this actually happened. Someone in Texas lets people buy specialty license plates. You know, I love little warm puppies and stuff like that. You can buy a specialty license plate. And somebody wanted to have a specialty license plate that pictured the Confederate flag. And Texas said no. And the Supreme Court said Texas doesn't have to do it, government speech. So isn't that inconsistent with what you just said?
Senator, it is not inconsistent. This area of law is extremely complicated when something qualifies as a public forum such that viewpoint discrimination might not be allowed versus a public benefit and public conditions that the government can rightly impose on others, on its recipients. Then that shades into government speech, in which case the government would have more control over what kind of speech gets projected into the public square. But there is potential for tension there between the two doctrines that you raised, Senator.
The chairman's going to gavel me to shut up in a second. I just want to be sure I understand. Back at Yale, you said there are some things that women are better at, right?
Yes, Senator.
Not worse.
That's right.
Better.
Yes, Senator.
Okay. Thank you, Mr. Chairman.
Senator Whitehouse. Well, thank you, Chairman. Mr. Dunlap, it appears that you were active in Maine against a ballot initiative legalizing same-sex marriage. Is that true?
I believe you're referencing simply an op-ed that I published that expressed at the time my disagreement with the theft of political signs through that
If you were not active against that ballot initiative, why would you be engaged about political signs?
I lived in the area in which I observed that political signs were being stolen, and in my view, the First Amendment
that
is
was,
there.
in your testimony to us is that that was only about political signs, that you did not take an active part in the anti same-sex marriage ballot initiative.
I did not play a part in that ballot initiative, no.
I'm sorry, say
I
again?
did not take a part in that ballot initiative, no.
Even as a advocate? I mean, you weren't, when you say you did not take a part in it, what exactly does that mean?
I had no active role or participation in any campaign relating to that.
Did you say that gay marriage would affect our rights under the First Amendment, freedom of speech, and free exercise of religion?
Again, the position that I was taking there was that in the context of that ongoing political campaign, that there were thefts of political signs, and I expressed my disapproval of that. The political speech is central to the First Amendment.
But you also said that allowing gay marriage would affect our rights under the First Amendment, freedom of speech, and free exercise of religion. So you at least took that public position, did you not?
I did.
Which is a little bit different than taking no public position. You also supported a Maine bill entitled An Act to Allow a Wrongful Death Cause of Action for the Death of an Unborn Child. Could that statute be applied to a woman seeking an abortion or to a doctor providing an abortion?
So that proposal would have brought Maine's law into line with that of all other New England states. It does not apply in the context of abortion. It would have given grieving parents the opportunity to recover for a tortious death as that was defined in the statute.
But not one provided, not one related to the woman obtaining medical care.
Again, that statute exists throughout New England except for the state of Maine, and it has not affected abortion rights in those states.
When you were in law school, you interned for a nonprofit whose purpose is to oppose women's reproductive rights and to oppose marriage equality and to oppose the right of LGBTQ couples to adopt children. Did you intern for that organization because you supported or shared those views?
I was a Blackstone Fellow. I participated in a program that offered training in First Amendment law, draws from a wide variety of law schools across the country, and offered the opportunity as well for an internship. I spent my internship that summer as a research assistant for Professor Garnett at the University of Notre Dame.
Do you have choices in what group you interned with?
I applied to that for that job.
You
yes.
applied for that job for that group that has as its purpose to oppose women's reproductive rights, to oppose marriage equality, and to oppose the right of LGBT couples to adopt children, correct?
I applied for the Blackstone Fellowship, which is run by ADF, which is a highly successful law firm.
And you chose to do that internship at ADF, correct? You weren't forced there, you weren't driven there, this was your choice to do that. You picked that internship and you picked that organization.
That's correct.
And yet you say that you had no view on the same-sex marriage question in Maine, even though you devoted yourself in law school to interning for an organization that opposes same-sex marriage.
I don't believe I ever testified that I did not have a view. I said I did not participate in the campaign.
Yeah, well, your version of participate seems a little squirrely to me when you're actually writing op-eds related to that question. I will leave it there because my time has expired, but I hope that we'll get real answers, Mr. Chairman, to our questions for the record. I've been told that Republican members are telling witnesses that they actually don't need to answer questions for the record. And we've seen sham answers to questions for the record. this committee is spiraling away from being the least bit responsible with respect to our oversight, and I would hate to think that QFRs no longer matter in the Judiciary Committee of the United States Senate. Thank you.
Congratulations to both of you on your nominations. And Mr. Dunlap, I'm pleased to support your nomination. Mr. Tong, same. But I want to ask you why you neglected to talk about one of the most important parts of your background, and that is the fact you were born in Houston, Texas. Is that correct?
Senator, I was not born in Houston, Texas, but my brother did attend Rice University in Texas.
Okay. Well, tell me a little bit about your family. I see your parents are here, and what did you learn from your?
Could you say that again?
What did you learn from your parents growing up that's made you the man you are today?
Senator, I learned everything from my parents. My parents immigrated from Taiwan, and their parents, my grandparents, immigrated from communist China. My dad, he is an entrepreneur in the construction business. He laid tile and constructed kitchen cabinets for houses in our community and for other businesses. My dad got his MBA at the University of Dallas when he was an exchange student in the US. My mother, my dear mother, she graduated with a master's in education at USC in California, and she raised two boys, my brother and myself, and I couldn't be prouder of my parents, and I hope I'm making them proud today.
Well, I was a little stunned by some of the initial comments by two of my colleagues from California, and it sounds like they were painting you as some sort of radical. Do you consider yourself to be a radical?
I do not, Senator.
Well, you've had a pretty impressive background in terms of your education, University of Chicago Law School, Yale University. By the way, you spent a year abroad studying Chinese?
I did. It was an exchange program, and I studied the Chinese language.
And why did you want to do that?
Well, at the time, I had wanted to enter the Foreign Service and have a career in diplomacy. So I thought, well, learn Mandarin that could be useful in the future. But while I was there, I changed my mind and decided to apply to law school.
And you clerked for Justice Gorsuch and Justice Scalia. Do you consider them role models?
I do, Senator.
And when you talk about originalism, I believe both of them embraced this approach to the work of the judge on the Supreme Court of originalism. Could you just explain what originalism is and why you support it?
Thank you, Senator. Originalism is the method of interpreting the Constitution that looks to the original public meaning of the text when it was ratified. It gives the power to the people and not to unelected judges who have life tenure. It prevents judges, ideally, from indulging in their personal policy preferences, and it requires them to stick to the text and history and the original meaning of the Constitution when it was ratified.
Well, you've been asked about all sorts of hot-button issues, from same-sex marriage to the gender equality to you name it. Is that your job as a judge to basically make those sort of policy judgments or try to reconcile or find consensus among divergent views among Americans?
Senator, my job, if I were so confirmed, lucky to be confirmed as a judge, would not be as a policymaker.
And I can tell you that probably all 100 members of the Senate would be grateful for the statute of limitations on dumb things they said when they were in college. But thank you for clarifying your views. I'm kind of stunned myself that colleagues would want to go back to comments you made in college and somehow impugn your record or your ability to serve as a circuit court judge based on some comment you made back then. But in the short time I have remaining, I'm intrigued by one last thing on your resume. You were a member of the International Defensive Pistol Association. What in the heck is that?
It's a competitive shooting organization, Senator, that seeks to promote self-defense knowledge and self-defense training.
Thank you. My time's up.
Senator Ronald.
Thank you, Mr. Chairman. I asked the following two initial questions of all nominees to ensure the fitness of the nominees to serve. So I'll start with Mr. Dunlap and then Mr. Tong. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
No.
Can't hear you.
No, Senator.
So, Mr. Tong, you have been asked questions about originalism, and you are an originalist, correct? You have written about it, the importance of originalism.
Senator, I subscribe to originalism, but I would be bound by Supreme Court precedent.
Well, sometimes there is no Supreme Court precedent. So let me just mention that pretty recently in March, this past March, you wrote, quote, "In my view, there is no real rival to originalism when it comes to the proper method of interpretation." And you noted at the same time that, I'm quoting you, "Originalism recognizes that there may be hard cases, but most cases, including the high-profile ones, are not hard, whether there's a constitutional right to abortion, same-sex marriage, sodomy, pornography, transgender protections. The answer for the originalist is simple: no." Do you think that all the members of the United States Supreme Court share your perspective and your view on originalism?
Senator,
Yes or no?
Senator, I understand the justices on the Supreme Court hold different views on the method of interpreting the Constitution.
So not all of them hold your view that originalism is like no real rival to how things should be interpreted. So, Mr. Tong, as a lawyer and prospective judge, do you believe that court orders must be followed by parties to a court unless and until they are ordered by overturned by an appellate court? Again, yes or no? Should court orders be followed?
As a general matter, Senator, court orders should be followed by the parties that are bound to it.
Well, I don't know what the general matter is. You know, you should. I would think that court orders should be followed. So, do you believe that someone who contemplates disregarding court orders is qualified to get a lifetime job as a judge? Yes or no?
Senator, you're asking a question that implicates a current issue, and under the canons of judicial conduct, I should not and cannot answer.
Well, you know what? There should be judicial conduct that says all judges should believe that judicial orders should be followed. So you know that this is a matter of concern to quite a number of us on this panel. So you were asked various questions about your views on the role of women and that women can do certain things better than men, and I take it that you believe men can do certain things better than women. And the fact that you may have held these views 20 years ago doesn't mean that you no longer hold those views, because I held certain views when I was in college, such as public service is a good thing. I still hold that view. But yet when you were asked whether you still believe in these gender roles, which are very limiting, frankly, in my view, you said that the canons of ethics prohibits you from answering. So do you, I mean, that's like, this is going to be a live question. Should you become a judge in the Ninth Circuit, do you actually think that there could be a live question on whether or not a woman's gender role is going to come before you?
Senator, questions relating to, for instance, the 14th Amendment's Equal Protection Clause could come before me, and for that reason, I consider that a live issue, and I wouldn't be able to answer under the
okay,
canons.
well, you know what? We didn't talk about the 14th Amendment, which, by the way, as far as I'm concerned, is supposed to provide equal protection for everyone, regardless of race, religion, etc. But frankly, what is happening with the 14th Amendment is that it is being weaponized. in my view, that this is a Supreme Court majority that is not exactly holding the 14th Amendment to provide equal protection for everyone. So I just have one more question. You talked about what you call the radical left. What do you mean by radical left? People on the radical left are saying things that are not truthful. What do you mean by the radical left?
Senator, I am unsure from where you're pulling that phrase. I don't have the context to answer, Senator.
You do remember talking about the what you consider to be radical left. Mr. Chairman, I hope that I can submit some questions for the record, and it's so disturbing to me that there are some of our nominees who think that they don't have to really respond. I hope that you are not among those, because I will have some questions for the record. Mr. Tong?
Appreciate it, Senator.
Thank you.
Congratulations. I know that you all are pleased to be here, and I congratulate you on your nominations and do indeed look forward to your confirmations. Mr. Dunlap, I want to come to you. I know that you have been a litigator and an appellate litigator. So talk to me about the experience you bring in that capacity and now that you're going to be on the court. And is there a specific case that you think the briefing the court, that the entire process really informs the way you would approach the bench?
I think one similarity that would transfer from being an appellate advocate to being a judge, should I be confirmed, is the necessity of carefully analyzing the law and being able to distill it in a thoughtful and understandable way. I think that a judge has the obligation to write in a way that meets, to fully explains the judge's reasoning to the parties that appeared before the court, and would provide useful guidance to future parties that may be affected by similar cases. So I think that you have to have that same skill set when you're an appellate litigator as you would if you were on the bench.
Okay. Mr. Tong, let's talk about, I don't think you've talked about this yet, a town hall op-ed that you did in 2019. And it was responding to what you called, and I'm using your term, a misguided hit piece by a law professor who criticized Justices Scalia and Gorsuch and asserted that originalist judges make stuff up too. So you took issue with that, and you made the case for originalism and the framework and that approach for constitutional interpretation. So elaborate on the points that you made in that town hall op-ed and why you think, and you've talked a little bit about this today, why you think originalism is the correct approach for constitutional interpretation.
Thank you, Senator. Originalism anchors judges who are not elected and who are not politically accountable, anchors them to the text of the Constitution. And so it forces them to show restraint and to not exercise their will, but to exercise judgment, in the words of Hamilton in Federalist number 78. In that op-ed you had mentioned, Senator, the case that was addressed, that was used as an example of originalists making stuff up, was the Kylo versus United States case, which addressed the Fourth Amendment and what constitutes a search under the Fourth Amendment. Justice Scalia wrote the opinion holding that using a heat thermal imager of a home that would allow the police to surveil the interior of the home, that constituted a search, despite the fact that thermal imagers weren't in existence at the time of the Fourth Amendment's ratification. The Fourth Amendment would still have application. The meaning of the search doesn't change over time. And so in that instance, I don't believe that Justice Scalia was making stuff up as the author of the article I was responding to was suggesting.
Okay. And you also said in that op-ed, when judges stray from text and original meaning, we end up with topsy-turvy results. So expand on that.
Yes, Senator. So when one strays from the text and veers into other sorts of doctrines under the Fourth Amendment, for example, the Katz doctrine, reasonable expectation of privacy, when that becomes the controlling test, what happens is searches that were searches under the original meaning of the Fourth Amendment no longer become searches. So when helicopters search other people's property, that constitutes a search, does not constitute a search anymore, because under the Katz view, there's no reasonable expectation of privacy. It's no longer moored to the text of the Constitution.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And to all the nominees today, it's obviously a time in America where we should recognize people who want to step forward and serve in the public interest, do so at often great sacrifice, not just to themselves, but to their families. So I just want to recognize that this is a very important part of our American tradition, and people that step forward for these offices should be commended for doing that. Mr. Tong, I want to jump right back in to where my colleague was asking you about Mike Davis, if you don't mind me to dig in a little bit more here. And if that's one of my videos, keep it playing. But if it's not me, you should cut it off right now. Do you agree with Mr. Davis that you guys are friends, correct?
We are friends, Senator.
Yeah, thank you. And Mr. Davis recommended you, or did Mr. Davis recommend you or otherwise mention you to anyone in the Trump administration for this judicial vacancy?
I believe he might have, Senator.
Thank you, sir. Do you know exactly what did he say or to whom he made that recommendation?
I do not know that, Senator.
Thank you, sir. Mr. Davis, did Mr. Davis, excuse me, or anyone else associated with the Article 3 project advise or prepare you for any aspect of this nomination?
No, Senator.
Okay, and Mr. Davis is the founder of the Article 3 project. According to the organization's website, he founded the Article 3 project after he helped Trump win the Gorsuch and Kavanaugh nominations. And Mr. Davis said that we saw how relentless and evil too many of today's Democrats have become. They're Marxists who hate America. They believe in censorship. They have politicized and weaponized our justice system. Do you agree with Mr. Davis's statements that today's Democrats are relentless and evil?
Senator, Mr. Davis's views as expressed there are not necessarily the views of mine.
I didn't ask if they were necessarily. I just asked, do you think that today's Democrats are relentless and evil?
Senator, you're asking me to comment on a political question, and as a nominee to a judicial position, I cannot and should not speculate or comment on that.
Sir, I spend a lot of time working to try to affirm this fact that we are one nation under God, that the lines that divide us are nowhere near as strong as the ties that bind us. I'm proud of my relationships with my friends on the other side of the aisle. I think it hurts Mr. Kennedy to when I say that he and I are friends. I could say unequivocally, Republicans are not evil, but you're telling me you will not say on the record here that Democrats are not evil?
Senator, you're asking a personal and policy-laden question that I cannot answer.
So put yourself in the position of a person coming before you who's watching this right now and you're supposed to be a judge who's impartial, and you're telling me that for this nomination, I have a constitutional obligation to advise and consent, that I should be in any way hopeful that a judge will be that impartial if he cannot say that Americans writ large, because of their freedom of party association, that you can't say that whether you're deciding to be a Democrat or Republican or independent, you can't say in this hearing that you don't think that that makes a person evil?
Senator, I can commit to this committee that whoever comes before my court, should I be fortunate enough to be confirmed, will be treated with respect and their arguments will be
and not
accorded.
A presumption that they are evil.
Senator, whoever they are, Republican or Democrat or independent, who steps to my court, they will be accorded full consideration of their arguments.
Mr. David, I don't know what you're afraid of. I really don't, Mr. Tang. I honestly don't know where have we gotten to the point in American history that someone up for a position such as yours, and I've seen this courageously from people on both sides of the aisle who understand that the judiciary should be above partisanship, who understand that the judiciary in many ways should be a sobered assessor of fact. It is deeply disappointing to me that you cannot tell the American public right now that the person that you're affiliated with their heated language, with their casting in broad brushes, doubling down on the toxins that are making life here dangerous. And frankly, I've talked to federal judges who tell me about having to protect themselves. We had a horrific incident in our state where a federal judge was targeted, their husband shot, their son killed. In this time in America, to render an answer of, I can't answer that, to me is additive to the toxins that are in our society that are pitting people against each other. You are up for a position in the highest court in the land, and you can't simply say, I don't think Democrats are evil. Is that what you're telling me?
Senator, I wish I were up for a position in the highest court of the land, but I'm up for the Ninth Circuit Court of Appeals.
Sir, to Americans, the federal courts are the highest courts in the land. So I appreciate your correction and your diligence and dutiful attention to detail. But right now, I am gravely disappointed that you can't simply say what I can say is that my colleagues are not evil, that Democrats are not evil, that Republicans are not evil, and this kind of rhetoric is damaging. I am deeply disappointed, sir.
I'm the chairman now. We've got a new sheriff, and I'm going to call on Senator Schmidt. But before I do, Mr. Tong, I'm going to give you another chance. I want you to think real hard. I looked at your record. I think you're a good man. You really don't think that somebody's evil just because of their party they're in America, do you?
I don't think that, Senator.
Oh, God bless. Thank you, sir. That's the answer I was looking for, and I don't understand why you wouldn't answer me, maybe because I'm a Democrat, but dear God, that's the easiest question I've heard asked today, and thank you, Chairman Kennedy, for eliciting what is a response we should get from any American who's up for a federal position.
I don't think Senator Booker was trying to trick you. You don't think Republicans are evil, do you?
I do not.
And you don't think independents are evil, do you?
No, Senator.
And you don't think Democrats are evil, do you?
Senator, I do not.
Good. Senator Schmidt.
Thank you. Thank you, Mr. Chairman. I also want to, I appreciate, even though you answered the question, I appreciate your restraint on that. I wish more judges would show that kind of restraint in weighing into political questions like Judge Boasberg. Judge Boasberg, before he had any of these cases that he's wrongly decided and been slapped down by the Supreme Court, opined that President Trump wouldn't abide by court orders, which is not true. And I'm glad the Department of Justice has referred Judge Boasberg for disciplinary action. Because judges have no role in weighing in on political questions or making political statements. That's not their job. And I would argue that the more they do that, it debases the respect that the American people will have for our courts if they view them as politicians. So I appreciate the sentiment. I'm glad we don't think everybody's evil, but I appreciate the restraint that you're trying to exhibit in this hearing. And I wish, again, Judge Boasberg would have exhibited that restraint, because not only is he a terrible liberal activist judge, he's also lost the respect and should be disciplined. I'm glad the DOJ has moved forward with that. I want to just take a moment to talk about and by the way, the Article 3 project, I just want to say something, is doing a very important job of hitting back against a lot of the smears that have come judges' ways just because they happen to be appointed by President Trump. I mean, Judge Beauvais is the most recent example, so I appreciate their advocacy. I want to talk a minute about dissents. We can talk about, in the Dred Scott case, Judge Curtis's dissent that became the rallying cry for the abolitionist movement. In Plessy versus Ferguson, Justice Marshall Harlan dissented and laid the groundwork for Brown versus Board of Education. And in Roe v. Wade, Justice Rehnquist warned against the Supreme Court unilaterally inventing rights that lacked historical or constitutional grounding as a fundamental right. In lower courts, you had Justice Alito's dissent and the Casey decision, which gave the pro-life movement, I think, a lot of hope for the days ahead. I could go on, and I bring this up because for both of you, it's going to play a very important role in the job that you have in front of you. The Ninth Circuit is historically the most overturned circuit at the Supreme Court in recent decades. In the past 2 years, the First Circuit, which has 0 Republican-appointed judge, has been reversed in 100% of the cases the Supreme Court has taken up on the merits. We need judges who are willing to stand up on principle. There's a lot of heat coming your way. There's a lot of vitriol that will come your way. But beyond just the judicial philosophy that I think is really important, it is the courage that it's going to take in many ways to stand on a judicial island in many ways on the First Circuit, on the Ninth Circuit, in the places where there just aren't a lot of conservative judges that have been appointed by Republicans. And so I think in many ways this will be the real test for a lot of the judges that come before this committee. It's not necessarily, I mean, obviously originalism and textualism, those are very, very important creeds that I certainly subscribe to. But you really need people who, when they're in the arena, are going to do the right thing and maybe, just maybe, articulate an argument that will be upheld at some point somewhere else. So, Mr. Dunlap, I wanted to ask you, if you're confirmed, you'll be the only Republican-appointed judge on the First Circuit. As I mentioned, it's been reversed 100% of the time by the Supreme Court. And there's only 4 active district court judges in the First Circuit appointed by Republicans. And the Supreme Court's already had to clean up some messes that the First Circuit has created. How do you view your future role as a judge in the First Circuit in writing even dissential opinions, not only just dissents, given the likelihood you're going to find yourself on an island?
Well, Senator, Mainers are famously independent. I suspect that characterizes me as well. I believe that it is important to work collegially with one's colleagues to reach the best decision possible. I think it is also important that when there is a disagreement, that a judge be willing to write independently, to write a dissent if necessary. I believe that dissents and concurrences can help further the dialogue within the court, can highlight important issues for consideration in the future. And yes, in certain circumstances, it may call attention to an issue that may warrant review by the Supreme Court. So in all of my efforts, should I be confirmed, I would seek to work both collegially and independently on the court.
Mr. Tong, how do you view that as well?
Senator, judges take an oath to uphold the Constitution, and if that means requiring writing a dissent, I will do that if I were confirmed on the Ninth Circuit. Justices Scalia and Gorsuch wrote numerous dissents, and I hope to follow in their stead where necessary.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Coons.
Thank you, Senator Kennedy. Thank you to the nominees, to Mr. Tong and to Mr. Dunlap, for you and your family's willingness to serve. Mr. Tong, in particular, thank you for your service at DOJ. And I just wanted to ask both of you, if I could. The record reflects you both met with President Trump on July 2nd to discuss your nominations. Is that correct?
Yes, Senator.
That is correct.
Who attended that meeting, Mr. Dunlap? Where did it occur, and what was the topic of discussion?
We met in the Oval Office. I believe we were accompanied by the Chief Counsel, and so we generally discussed background judicial philosophy.
Mr. Tong, what did you discuss at the meeting, and what sort of questions were you asked?
Senator, we discussed my background and qualifications.
As far as I can tell, during both the Biden administration and the first Trump administration, personal meetings by the President of the United States with circuit court nominees were exceedingly rare. Why do you think, Mr. Tong, that President Trump wanted to meet with you personally?
I don't know, Senator.
Mr. Dunlap?
I agree, I don't know.
Anything that struck you as unusual about the questioning around your judicial philosophy?
No, I was honored to be able to appear in the Oval Office.
It is an honor to be in the Oval Office. I can agree with that. Mr. Tong, when you were in private practice, you represented a number of cryptocurrency clients, including a Coinbase employee who later pled guilty to wire fraud. If confirmed, would it be your intention to recuse yourself from any cases related to cryptocurrency?
Senator, recusal will be assessed again if I'm so fortunate to be confirmed on a case-by-case basis based on the facts and based on the degree of the relationship I might have with the matter at hand.
But does it seem to you that having had a number of cryptocurrency clients, the presumption should be in favor of recusal?
Not necessarily, Senator. It is a fact-specific inquiry that I would engage in
I know.
carefully.
I'm familiar with the inquiry. What about cases brought by Jones Day?
I may recuse for a time in cases brought by my firm, Jones Day.
Why would the recusal be time-bound?
Well, because after a period of time, the conflict of interest and the perception of the conflict of interest may have dissipated and be banished.
Can you give me any
entirely.
sense of what that period of time might be in your estimation?
I will assess that question, Senator, and I will consult my colleagues on how to apply that particular statute.
What sort of factors do you think you would weigh when considering whether to recuse from a case involving Coinbase or Jones Day? Just give me a little more color as to what kinds of things would cause you to conclude you had a potential conflict of interest or an appearance.
Sure. The parties, the relationship that I may or may not have with the parties involved, the kinds of legal issues that are implicated in the case at hand, whether I had been personally involved in the matter as a private litigant. I think all those would be factors that I would consider.
Mr. Dunlap, I want to talk about one of the pillars of our judicial system, stare decisis. You've written a blog post for your firm about when it might be appropriate for a court to overturn established precedent. If confirmed, when would it be appropriate for you to draft an opinion overturning First Circuit precedent?
So First Circuit precedent could only be overturned en banc, and the court would consider the importance of the issue raised, would consider potential conflicts with other cases and determining whether or not to take it en banc. And if the court did take a case en banc, you would consider a variety of factors. You would consider reliance interest. You'd consider the quality of the legal reasoning. You would consider subsequent...
Help me understand, Mr. Dunlap, if you might forgive me, the contours of reliance interest.
So the reliance interest is the extent to which parties may have shaped their conduct in a way that is relying upon the existence of a particular precedent.
And would a precedent that had been well settled for, let's say, 50 years be one that would likely have produced reliance interest?
That would be a possibility. It would certainly be a consideration that the court would need to take into account.
What would you do if asked to apply Supreme Court precedent with which you disagree?
I would be bound by the rulings of the Supreme Court.
And what are the contours of being bound?
I mean, you need to look as a judge at the facts and the legal reasoning of the case, determine how it applies to the case before you. But the court's holding is binding on lower courts.
Thank you both. Thank you, Mr. Chairman.
Senator Cruz.
Thank you, Mr. Chairman. Congratulations to both of you. Today, we consider two exceptional nominees, Joshua Dunlap for the First Circuit and Eric Tong for the Ninth Circuit. Both are accomplished appellate advocates, constitutionalists, and exactly the type of judges President Trump promised to nominate. Judges committed to following the law as written, not as they might want it to be. This matters because for decades, the First and Ninth Circuits have been among the most activist courts in America. Too often wrong on the law, too often hostile to the Constitution, and too often willing to substitute their own left-wing politics for the rule of law. The Ninth Circuit is notorious for its extreme activism and wildly incorrect rulings. It is by far the largest circuit in the country, covering 9 western states, including California, Washington, and Oregon. And still, the circuit overreaches, trying to dictate policy decisions far beyond its bounds. For years, the Supreme Court has had to correct its radical rulings. In Kennedy versus Bremerton School District, the Ninth Circuit upheld the firing of a high school football coach for the, quote, unconstitutional act of praying at the 50-yard line. Not only did the Ninth Circuit trample Coach Kennedy's free speech and free exercise rights, the opinion even criticized Kennedy's faith itself, suggesting that his public prayers defied the Sermon on the Mount. The Supreme Court reversed 6-3, restoring Coach Kennedy's constitutional rights and repudiating the Ninth Circuit for its overt hostility to religion. In California versus Greenwood, the Ninth Circuit invented a Fourth Amendment privacy right in trash. The Supreme Court reversed that decision because garbage at the curb has no privacy protection. In Ashcroft versus Al-Kid, the Ninth Circuit held that a former U.S. Attorney General could personally be sued for detaining a terrorism witness. Again, the Supreme Court reversed 8-0. In Peruta versus San Diego, the Ninth Circuit declared there is no Second Amendment right to carry a concealed firearm, a ruling later gutted by the Supreme Court in Bruin. And just this week, I am leading an amicus in Nome versus Al Otro Lado, a case that epitomizes the Ninth Circuit's lawlessness. The Ninth Circuit held that an alien standing on the Mexican side of a U.S. port of entry has, quote, arrived in the United States and can therefore claim asylum, creating a right that Congress never authorized. If allowed to stand, that decision would abolish border metering and would force CBP to process aliens in foreign countries and invite millions of asylum claims from people who have never set foot on U.S. soil. Our brief urges the Supreme Court to grant cert and to reverse the Ninth Circuit, because immigration policy is for the political branches, not for activist judges. The First Circuit, though smaller, is no less liberal. It covers 4 New England states from Maine to Rhode Island. Every single active judge on the court is a Democratic appointee, 4 appointed by Joe Biden and 1 by Barack Obama. That reality has made the Boston-based First Circuit a magnet for progressive litigants trying to block President Trump's immigration policies. On day 1 of President Trump's return to office, progressive groups filed 3 separate lawsuits in First Circuit district courts challenging his order to end birthright citizenship. They chose this venue deliberately. The First and Ninth Circuits show why judicial appointments matter. When unelected judges rewrite the law, fundamental rights erode, states are trampled, and the Constitution is replaced by politics of the bench. President Trump is rightly restoring balance. With nominees like Joshua Dunlap and Eric Tong, we are ensuring that the Constitution, not politics, rules in our federal court. I have a question for both of you. Can you tell this committee, in your judgment, what is the importance of the First Amendment to the Constitution? Mr. Dunlap.
The First Amendment has rightly been referred to as protecting some of our first freedoms, freedom of religion, freedom of speech among them. As a member of the federal judiciary, should I be confirmed, I would seek to equally apply that provision along with all other provisions to the parties who appear before me.
Mr. Tong.
Senator, the First Amendment is critically important to our Constitution, as the Supreme Court has held time and time again, including in the case you mentioned, Kennedy versus Bremerton.
Thank you.
All right, thank you, gentlemen. This concludes panel 1. We appreciate your testimony. Mr. Meredith, Mr. Mercer, please come forward. Stand at the witness table for me. Raise your right hand, gentlemen. Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. You're each given a few minutes to make an opening statement. We'll start with you, I can't see that far, Mr. Mercer.
Senator Kennedy, Ranking Member Durbin, and members of the committee, thank you for holding this hearing. I also want to thank President Trump for the honor of this nomination. I appreciate the support of Senator Daines and Senator Sheehy and the generous remarks offered by Senator Daines in his introduction this morning. With me today is my wonderful wife of 27 years, Marcy. Without her love, sacrifice, and steadfast support throughout our marriage, I would not have this opportunity. We are the parents of 2 adult children who are working today and unable to join us. They have brought much joy to our lives, and we are proud of their accomplishments. Reviewing my history as part of this nomination and confirmation process has been a reminder of how many people, too numerous to mention, have influenced my path. My brother and I owe much to 2 engaged and supportive parents, my 97-year-old mother and my father, who is no longer living. My dad entered public service as a legislator when I was 9 and gave me a window to see law and policy early in my life. I'm confident that I have pursued public service for nearly 30 years due to what he allowed me to see. But others deserve mention. I've benefited from instruction and guidance from many fine teachers and mentors. I have learned much from my colleagues in government, both in state and federal service, and for the last 15 years in private practice at the law firm of Holland and Hart. I've had support from friends and family along the way. I'm grateful to all of these people and look forward to the committee's questions.
Mr. Meredith.
Senator Kennedy, Ranking Member Durbin, and to all the other committee members, I'd like to say thank you for the opportunity to appear before this committee today. I'd also like to thank President Trump for the great honor of this nomination, and I'd also like to thank my home state senators, Senator McConnell and Senator Paul, for supporting me. I'm fortunate today to be accompanied by several family members, and I'd like to introduce and thank them. First and foremost is my lovely wife, Rebecca. This process can be a very stressful one, and I think that stress is perhaps in many ways most acutely felt by spouses of nominees. So I'm grateful that she's been willing to go through this process and has done so with such grace and poise. Also with us today are 3 of our 4 children. I'm very pleased to have them here, and I'm very proud of them. Our youngest son just turned 3 a few days ago, and we weren't confident he'd be able to sit through this hearing. Based on our experiences at church, we know that he doesn't always understand that events like this aren't two-way conversations involving him. So he's at home with my mother-in-law and a niece, and buddy, if you're watching this, just know that we love you and we miss you. Also with me today are my parents, Steve and Karen Meredith, my brother Bryce Meredith, his wife Kelly, and their 3 daughters, and my brother-in-law Joseph Link is here as well. I'm deeply grateful they all took time out of their busy lives to be here to support me. Several friends also made the trip to support me today, and I'm deeply grateful for that. They include State Representative Samara Heverin, Eric Lyken, Darren Embry, Kent Barber, and Blake Christopher. I want them to know how honored I am that they're here. I'm also grateful for all the family, friends, and colleagues who could not make it here today, but who are supporting me nonetheless. It's my understanding that something on the order of 350 lawyers and community leaders in Kentucky and elsewhere have registered their endorsement of my nomination. I'm deeply honored and flattered by this. Finally, I'd like to thank the 2 judges for whom I clerked, Judge Amul Thapar and Judge John Rogers. They both inspired me to pursue public service and a position in the judiciary, and the traits that they exhibited every single day provided a masterclass in how judges should comport themselves. They taught me that judges should be objective, logical, patient, reasonable, understanding, considerate, and above all, they taught me that judges should always, under all circumstances, set aside their own desires and preferences and simply do what the law commands, nothing more, nothing less. Should I be fortunate enough to be confirmed, that is how I will perform the job. Thank you for the opportunity to be here, and I look forward to your questions.
Thank you, gentlemen. Senator Durbin.
Thanks for being here, and appreciate your family and friends joining with you on this important day in your lives. Mr. Meredith, you heard my opening statement relative to the pardons that were given by the governor of Kentucky. Why don't we give you an opportunity now to explain the questions that I raised?
Senator, I can tell you that I learned about the governor's last-minute controversial pardons in the media after we left office. And I remember in your opening remarks, you mentioned the Baker pardon, and I can tell you without hesitation that I did not review that pardon file, and I did not advise the governor on that.
How about another individual who received a commuted sentence, Dayton Jones, child predator convicted of sodomizing an unconscious boy and causing life-threatening injuries?
Same answer, Senator. I did not review that file, nor did I advise the governor on that.
Who advised the governor in terms of his pardon policy?
Well, there were several lawyers in the office. I don't know who advised the governor. I don't know if anybody did. You know, perhaps the general counsel did. I would be speculating, Senator. It wasn't me, and I don't know.
Mr. Mercer, there's some question as to, I'm not going to go into the history with the U.S. attorneys. Let someone else raise that if they wish. But I'd like to ask you about your characterization of the January 6th defendants. Did you make a recommendation to the Montana Republican Party to insert a characterization in their platform that the January 6th defendants were being held in indefinite detention?
Ranking Member Durbin, I do not believe so, and I certainly have no recollection of that.
What is your feeling about the prosecution of the January 6th defendants? It's become something of an issue here.
Ranking Member Durbin, my view is that those are cases that were considered by the department and brought and adjudicated in the system, and the outcomes are clear, and I don't have anything really to add on that issue.
What is your reaction to the full and unconditional pardon of the January 6th defendants by President Trump?
Ranking Member Durbin, my position on that is that the pardon power is something that the judiciary has no involvement in, and as a nominee for this position, I don't believe it would be appropriate for me to comment on that issue.
While serving in the Montana State Legislature, you initially opposed a bill designed to eliminate the 3-year statute of limitations for civil lawsuits by sex abuse victims. A group of survivors were critical of you and said that you made a total sellout in favor of child molesters and insurance companies. I'm relieved that despite your opposition, a compromise bill was enacted. If confirmed, how can victims of sexual abuse rely on you to rule on their cases fairly and justly given your opposition to extending the statute of limitations for these types of cases?
Ranking Member Durbin, I respectfully disagree with your construction of the matter. The bill in 2019 was brought to create an unlimited statute of limitations with respect to child sexual abuse hands-on offenders. And we looked at what had occurred nationally in terms of similar statutes with a healthy respect for what statute of limitations bring in civil cases, which is the ability to have measures brought in a timely fashion. We ultimately surveyed nationally what those provisions look like in other states, and we concluded that most states allowed victims of child sexual hands-on offenses to bring those cases sometime after reaching majority, and usually for some period of time after reaching majority. So the statute that we ultimately passed created the ability to bring that case up to, I believe it was age 26. It was either age 26 or 27. That puts Montana code firmly in line with what other states have done. And the key thing in that legislation that we did was create a much more robust reporting mechanism that allows us to have clarity, or rather allows the Attorney General of the state to have clarity through the county attorneys on matters being referred for investigation by the Department of Public Health and Human Services. So we thought it was very important legislation, and we're pleased with the outcome.
Mr. Meredith, beginning in 2017, you defended a Kentucky law that required doctors to present certain information to patients before the performance of an abortion procedure. As part of your defense of that law, you stated, and I quote, "Not every patient understands the consequences of an abortion procedure." You further stated, quote, "There are a number of patients who don't understand the nature of the fetus within them." Mr. Meredith, what was your basis for asserting that female patients do not understand their own medical needs?
Senator, my recollection is that those arguments were rehashing for the court the evidence that was in the record. My recollection is that there were several sworn declarations in the record.
What were the sources? Do you know?
I'm sorry, Senator?
What were the sources of those statements?
Those were declarations from individuals who had received abortions in the past.
You believe that female patients are less likely or less able to understand medical advice than male patients?
Senator, I'm sorry, I'm not sure I understand your question. Could you?
Well, you said not every patient understands the consequences, and we certainly know that we're talking primarily of women of childbearing status. And you went on to say there are a number of patients who don't understand the nature of the fetus. Do you believe that female patients are less likely to understand this?
No, Senator, what we were saying in those arguments is we were summarizing the evidence in the record for the court. There were several witnesses who testified by sworn declaration that they wished, my recollection is they said they wished they had had that information because they didn't quite understand the nature and the consequences of
Didn't understand the nature of the fetus, women?
My recollection is that the testimony in the record in those sworn declarations said that that would have been helpful information that they would have liked to have had. And I believe that also was kind of hearkening back to statements in the Supreme Court's Casey opinion, as well as perhaps Gonzalez v. Carhart.
I'm going to tell you, I don't understand what you're saying based on this quote here. And if you wish, it's your decision. If you want to clarify what you've just said in light of what I quoted, please do so, because at this point, I believe there's really a serious question as to what you were trying to say.
Senator, we were just simply making an argument based on the evidence in the record, and it was the
Your
Commonwealth's
decision as to whether you want to clarify it, but at this point, I think it's going to be a problem for some of us. Thank you very much.
Senator Welch.
Thank you very much, Mr. Chairman. I think it is. Mr. Meredith, I want to ask you about these pardons, and I know you've been asked about it, but my understanding is that Mr. Baker, he posed as a U.S. Marshal. Is that correct?
Senator, I don't know. As I told Senator Durbin, I did not review any pardon file for Mr. Baker and did not advise the governor on that. So I'm not aware of the facts and circumstances.
Seriously?
Senator, I've read about it in the media.
So you're aware?
Well, I don't know the specifics of what you're talking about. I generally know that an individual with that name received a pardon, but I don't know the facts and circumstances of any of.
I'm asking you whether you know that he posed as a marshal.
I do not know that, Senator. I don't know that. I know that he was convicted. Well, my understanding is that he was originally convicted of a murder, I believe, but I don't know the facts and circumstances, Senator.
I mean, this was widely reported in Kentucky. It was very controversial.
Well, Senator, I think this was in the news maybe roughly 5 years ago, and all the details that were reported escaped me.
Senator McConnell said that this was completely inappropriate. Are you aware of that, to pardon him?
Senator, I recall that many elected officials made comments about that. I don't remember specifics.
You know what? You're a lawyer.
Yes, sir.
And you understand specificity matters, right? I'm not asking you what you knew from personal experience. I'm asking you what everybody in Kentucky knew. This guy posed as a marshal. That was widely reported, right?
Senator, again, you're asking me about facts that I just don't know about. I don't recall that from the you might be right,
Okay,
Senator. I don't know.
You know what? Be serious here. This is like incredibly controversial. I mean, so much so that Senator McConnell called it out as completely inappropriate. Everybody knew about it. This guy posed as a marshal. You're saying you don't know about that, even though it was widely reported. He murdered somebody, right?
My understanding, Senator, is that he was convicted of a murder.
And he killed a man's wife. He held this person he killed, he held his wife, that man's wife and his kids at gunpoint, right?
Senator, I don't know. You're asking me about specific facts and circumstances.
In 2017, a state jury found him guilty.
Senator, I understand that it's my understanding that he was convicted, but you're asking me about facts and circumstances that I'm not aware of.
Well, all right. I'll pretend you're telling me the truth, and I'll enlighten you as to what happened. In 2017, a state jury found him guilty. He got a 19-year prison sentence, right?
Senator, again, I don't know
all right,
all the
just
facts
take
and
it from me. We'll just assume I'm telling the truth. And he got a 19-year sentence. In 2018, Baker's brother, that's the man who was pardoned, hosted a fundraiser at his home for the governor, Matt Bevin. You worked for him, right?
I was in the counsel's office in Governor Bevin's office.
All right, so when I asked the question, did you work for him?
Yes.
Is the answer yes?
Well, I worked for him in the governor's office while he was governor.
So you worked for him?
Correct.
And his brother hosted a fundraiser, and Governor Bevin got $21,500, right?
I don't know. I have seen in the media.
All right, I'll let you know that's what happened.
Okay.
And in Governor Bevin's final days in 2019, he pardoned Mr. Baker.
I have seen media reports to that effect.
Right. And he had served 2.5 years of his 19-year sentence. So let me just ask you this. You agree with that pardon?
Senator, I did not review any pardon file for Mr. Baker. I didn't advise the governor on that. That's a discretionary function belonging to an executive
you know, we
branch
all know
official.
that. The governor can do what he wants. President Trump can do what he wants with the pardon power. I'm just asking you, do you agree with it? The guy shot somebody in front of his wife and kids. He got a 19-year sentence. He served 2.5 years. His brother gave a $21,500 contribution to the governor, and lo and behold, he got a pardon. Do you agree with that?
Senator, I'm not aware of all the facts and circumstances.
While you were the governor's counsel, there was a subpoena to get the records so that people could understand what the deal was on why this murderer got a pardon, and you resisted the subpoena, right?
Well, no, Senator. So what happened was, several of us. No, I did not. I told the governor's office I'd be happy to respond to that.
Well, the records went missing, as I understand it.
No, that's not true to my knowledge, Senator.
Well, where are they?
Well, my understanding is that the governor's administration currently has them.
And they resisted the subpoena while you were working as counsel for the governor?
No, I don't believe that's true, Senator.
But I see my time is up and my answers are not complete, but I can ask some follow-up questions. Thank you.
Senator Blumenthal.
Thank you, Senator Kennedy. Mr. Meredith, I'm very interested in your active membership in the Federalist Society. You were president of University of Kentucky's Law School chapter, and as an attorney, you served on the steering committee of the Connecticut Lawyers chapter. In 2021, you declared the Federalist Society is one of my favorite organizations ever. I love everything the Federalist Society does. President Trump has a different view. Apparently, he's routinely attacked the organization, claiming that it gave him, quote, bad advice, end quote, on nominees, and calling its founder, Leonard Leo, a, quote, sleazebag, end quote. I take it you disagree with President Trump on his views on the Federalist Society.
Senator, as a judicial nominee, it's not appropriate for me to comment on issues like that.
Well, I don't understand why not.
Well, Senator, you're referring to a personal political issue, and it's just not appropriate for me to weigh in on that.
Well, the Federalist Society, so far as I know, is not a partisan political organization. You're an active member of it. I'm asking you whether you agree with President Trump on its apparent failings and flaws.
Senator, again, it's just not appropriate for me to weigh in on that.
I don't understand why you're reluctant to express a view on it. You're a proud member of the Federalist Society, correct?
Senator, I have been a member of the Federalist Society off and on since law school, and what you're referring to is our comments and issues that are just not appropriate for a judicial nominee to weigh in on.
Is that true of all the organizations that you participated in, that they're not appropriate for you to comment on?
Well, I'm not sure. I mean, it would. If you're asking me to make assessments of individuals and organizations, I think that would be the case. I think it's not appropriate for me to make assessments.
You're a member of the organization now, correct?
I am currently a member, yes.
So I take it that you disagree with President Trump.
Well, Senator, again, I'm just not going to weigh in on any assessments of any organizations or individuals or anything like that.
Well, let me ask you on a different topic, since you're unwilling to answer those questions. You've made it no secret about your feelings on reproductive rights throughout your career. Given your long history of advocating against reproductive freedoms and rights, can we expect you to be fair and impartial as a judge if you're confirmed?
Absolutely, Senator. My job as a judge, should I be fortunate enough to be confirmed, will be to set aside all of my personal beliefs, all my personal preferences, all my personal desires, and simply do what the law commands, to uphold the rule of law in all circumstances.
Let me ask you, do you think Brown versus Board of Education was correctly decided?
Do I think Brown versus Board of Education was correctly decided? Yes, Senator.
How about Loving versus Virginia?
Yes.
And Obergefell versus Hodges correctly decided?
Well, Senator, I'm comfortable saying that Brown and Loving are correctly decided because I think those are so deeply entrenched in our nation's judicial tradition that I think there's absolutely no legitimate chance that anyone will challenge them. For other Supreme Court decisions, I'm hesitant to make an assessment because I don't think it's my job today to grade the Supreme Court or offer assessments of whether they're right or wrong. And, it's for other precedents.
Well, I'm disappointed in that answer. I think it's unsatisfactory given that Obergefell is established and well-accepted precedent. Let me ask you, Mr. Mercer, do you think Brown versus Board of Education was correctly decided?
Yes, I do, Senator.
And Loving versus Virginia?
Yes, I do, Senator.
How about Obergefell?
Senator, my position on that is that that's binding precedent that the Supreme Court has issued, and if I had that matter come before me, I would adhere to that binding precedent.
So you believe it was correctly decided?
I believe I would be bound by it precedentially, and I would follow it as precedent.
But you're distinguishing that Supreme Court precedent from Loving and Brown?
Senator, as this committee has heard from other nominees, given the passage of time and as my fellow panelists has indicated, that history, that you have heard from other nominees the same thing, and I believe that's the correct answer.
Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you very much, Mr. Chairman.
I'm sorry, what'd you call me?
I called you Mr. Chairman.
Well, thank you.
We're all calling you that right now because you are
Blumenthal
you
wouldn't
are
call me
holding the
chairman.
gavel,
I
sir.
never called him Mr. Chairman.
All right, Mr. Meredith, as Chief Deputy Counsel to the Governor of Kentucky, you defended, as my colleagues have discussed, you defended a law that imposed severe and medically unnecessary licensing regulations on clinics. That law would have had the effect of closing what was at the time the last remaining abortion clinic in Kentucky. You argued that the impact of closing Kentucky's last abortion clinic would be essentially none for women. Why did you argue that closing the clinic would not have an impact on the women of Kentucky?
Senator, my recollection of that argument is that, of course, now we are under the regime governed by the Dobbs case, but at the time we were under the Roe and Casey regime. And my recollection of that argument was that Casey, I believe, had said it's not an undue burden to have to travel up to 150 miles to obtain an abortion. And my recollection is that the evidence in the record showed that no one or almost no one would have to travel more than 150 miles to obtain an abortion should that clinic close, because Kentucky's geography is such that all of the population lives within 150 miles of facilities in other states, Senator.
Is it true that the closure at the time would have required women to leave the state and travel up to the 150 miles if they needed health care?
I think that's right, but Senator, one thing to keep in mind is the unique geography of Kentucky is such that many parts of Kentucky are much closer to facilities in other states than to that one facility in Louisville. So for instance, if you lived in southern Kentucky, you might be closer to Nashville or Knoxville than to Louisville. Or so it was that was the nature of that argument, Senator.
Last month was the 60th anniversary of Griswold, which established the right to contraception. In the Dobbs case, the Supreme Court clarified that its opinion does not threaten Griswold. They said nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. If confirmed, will you commit to adhering to the precedent established by Griswold and upholding the right to contraception?
Senator, I can commit to you that I will follow and faithfully apply all binding precedents of the United States Supreme Court.
Along those lines, Mr. Mercer, Chief Justice John Roberts wrote in his most recent end-of-year report that disregarding federal court rulings is, quote, dangerous, end quote, and, quote, must be soundly rejected, end quote. Do you agree with Chief Justice Roberts that any suggestion of disregarding a court's ruling must be soundly rejected?
Senator, I certainly have always advised clients to comply with court orders, and I believe that that is an essential feature. There, I believe, are extremely rare circumstances in which there may be a basis to challenge the existence of a court order. But again, throughout the entirety of my career, and if I have the honor of being confirmed, it will be my expectation that any party subject to an order that I issue would follow it.
Okay, but I think he was talking about not people appealing court rulings through the regular course. He said disregarding court rulings. And do you agree with him that this should be soundly rejected?
Senator, I believe that parties should comply with court orders. I believe that if they believe there's a basis to not do that, they should seek relief. So yes, I believe that court orders should be followed. And what I'm trying to say is I think there are extremely narrow circumstances where there may be a basis to say that there is a legal basis not to follow the order. It's extremely rare. I've never seen it. I've never counseled a party for whom I'm representing to take that position. And it would be my position, if confirmed, that it'd be my expectation that all parties, regardless of who they represent, comply with any orders that I issue.
Mr. Meredith, then I have one more question. Could you just quickly answer that one about Roberts?
Sure, Senator. I agree with the testimony of
other witnesses who have appeared before this committee in recent months, like Judge Whitney Hermendorfer, Solicitor General John Sauer, Professor Kate Shaw, all of whom I understand to have said the general rule is that a party before a court must obey the court's order. However, there are potentially certain narrow exceptions to that.
Okay, so just last thing, we were talking about the Kentucky law and your role, and given the fact that you didn't look at this as an enormous burden for these women to go 150 miles and to go to another state, what would you say to litigants who question that you can be even-handed in applying the law, including women trying to vindicate their rights?
Senator, what I'll say to that is that I will be fair-minded and even-handed with all litigants in my court, should I be fortunate enough to be concerned. And I think you can look at the fact that attorneys from all across the political spectrum and are supporting me, co-counsel, opposing counsel, people with all different viewpoints, and that's because they know that I understand the difference between being an advocate and being a judge. When I was an executive branch lawyer, it was my obligation to represent the Commonwealth and defend the Commonwealth's laws. But as a judge, it'll be my obligation to set aside all other personal beliefs, policy preferences, things of that nature, and just simply follow the law.
Thank you.
Mr. Chairman, may I have permission to enter into the record 2 articles from Louisville papers, one the Courier Journal and one from the Louisville News?
Without objection.
Thank you.
Mr. Meredith, you worked for Governor Bevin?
Yes, Senator.
You were his lawyer?
I was one of the lawyers in the office, Senator.
Okay. Governor Bevin issued some controversial pardons, is that right?
He did, Senator.
The FBI investigated those pardons, did it not?
Yes, Senator, that's right.
Did the FBI file charges against Governor Bevin?
My understanding is they did not, Senator.
Okay. Did you advise Governor Bevin on any of those controversial pardons?
The only controversial pardon that I advised him on was one for Mr. Irvin Edge, and I recommended that Mr. Edge not be pardoned.
And was he pardoned?
My understanding from reading news articles is that he was pardoned.
Okay, so the governor didn't take your advice?
Apparently not, Senator.
Okay. But you didn't have anything to do with any of the other controversial pardons?
No, Senator.
Okay. If the New York Times, Mr. Meredith, published an editorial, let's suppose it said, Senator Kennedy is a bad senator. We don't like him. We think he's an ignorant slut. And I called the New York Times, and I said, okay, I want to write a letter to the editor replying. Can the New York Times tell me no?
I believe that they could tell you no, Senator.
Well, what if I said, if they told me no, I said, okay, I want to buy a full-page ad that says John Kennedy's a good senator. He is not an ignorant slut. And they said no. Can they do that?
I think the First Amendment would allow them to exercise editorial discretion and control over the types of ads they want to sell.
You think it's purely a First Amendment case?
There could be. I mean, I think there are potentially other laws that could govern how they make their decisions to sell ads, but I think if they're making a decision about whether you can buy an ad that says Senator Kennedy is a good senator, I think I think the First Amendment would allow them to exercise.
Suppose I'm running for re-election after this editorial, and I go to my local television station and I say I want to run a political ad, and they say no. The New York Times says you're an ignorant slut. We're not going to run your ad. Can they do that?
I think that's governed. That's governed by different laws pertaining to the airwaves, which are governed by federal statutes.
There's only one Constitution.
That's right.
how can a news organization deny me the right to reply to an editorial that denigrates me, but yet I have a right to run a television ad that says the New York Times is wrong?
I think as in order to have permission to use the airwaves, I think federal law requires TV stations to give equal time or equal opportunity to buy
Why
ads.
is that constitutional?
Well, it's constitutional because my understanding, at least, is that the federal government controls the airwaves. Essentially, are federal property that the federal government can regulate and authorize the use of.
Yeah, but the federal government has to abide by the First Amendment, doesn't it?
It does,
I don't know.
Senator.
Explain to me how the New York Times can say no to me wanting a right of reply, but a TV station can't prohibit me from replying.
Senator, my understanding of the law is that the airwaves would be a public resource that the federal government regulates.
You think they're a common carrier?
I don't know the law on this specifically, Senator. I don't know that the common carrier analysis would apply there. Perhaps it would. I don't know.
Suppose I have my cell phone service with AT&T, and I call AT&T, and I say I want to expand my cell phone service, and they say nope. We read that New York Times article. You can't do it. Can AT&T turn me down?
I think theoretically they probably could.
No. How? Why? What basis?
Well, I take that back. You're right. They probably can't because it's the same thing.
Why?
They're using the airwaves as well.
They're a common carrier, right?
I think that analysis probably applies there. That's right.
Okay. Mr. Mercer, can Congress pass a law that says cities are no longer able to participate in zoning? We're going to take it over at the federal level because we don't have enough houses. Would that be constitutional?
Senator Kennedy, I don't believe it would be.
Why not?
I believe that's the sort of thing that the Constitution has, not given Congress the authority under Article 1 to do that, and in fact...
Why not? On what basis?
In our system of federalism, those things that are not set forth in the Constitution are reserved to the states, and zoning is one of those quintessential public health, safety, welfare matters that we reserve to local government to resolve. And so I don't believe it would be permissible for this body to attempt to codify something in that regard.
So local government would win in that instance.
That is my understanding.
Okay, suppose local government came back and said that not only now that we've won and we have jurisdiction over our own zoning and our own housing laws, if you want to build a new house in our city, the permit is now $50,000. Can they do that?
Senator, essentially, I think the same analysis applies. I think that the local government would have the ability to establish that, and I don't think Congress could overrule it, and I think they would have the inherent authority to do so.
Why isn't that a taking under the United States Constitution and the Fifth Amendment?
Senator, that would be a whole different analysis, but I don't believe...
Same analysis. We just established they have the right to zone as they wish, and so and to regulate local housing. They're doing it. They're saying $50,000 to get a building permit. You're telling me that's constitutional?
Senator, I believe it would be. I think that they could establish that they need, in order to engage in the permitting process and go through what they need to do as a local government. I doubt very much whether that would be a violation under a compensable taking under the Fifth Amendment.
You familiar with Sheets v. County of El Dorado?
Senator, no, I'm not. That is not something that I've encountered in my practice.
The Supreme Court struck down a a $23,420 fee for a permit to build a home.
I was not familiar with that precedent, Senator. I'll make sure.
At some point, local government, which has wide discretion when exercising its police power, at some point, their actions can step over the line, can they not?
That is true, Senator. And
violate what? The takings clause?
In this case, I'm not familiar with if Sheets was based upon the Fifth Amendment or if there was some other analysis, but...
It was Fifth Amendment.
Okay.
Y'all hungry? I am.
Yes, Senator.
Okay. All right, gentlemen, thank you. Thanks to all the nominees today. Written questions for the record may be submitted until August 6th at 5 o'clock. We would ask you to respond promptly. This hearing is adjourned.